Bičiulės ir bičiuliai, labas rytas, ačiū, kad padėti atskleisti teisingumą. Na, man labai malonu pasakyti, kad šis renginys yra tarptautinis, jame dalyvauja visa grupė ekspertų iš įvairių šalių, kurie taip pat dalinsis patirtim, kurie taip pat prisijungs prie mūsų diskusijų, na ir praturtins jas savo įžvalgomis, savo patirtimi ir savo patarimais. Na, aš noriu taip pat jūs visus, mūsų mylimi žiūrovai, būti aktyviais šio renginio dalyviais. Tai reiškia, jūs galite ne tik stebėtis su puodeliu arbatos rankose, bet ir pateikti klausimus studijos ir renginio dalyviams, taip pat komentuoti, replikuoti, transliacijos dešinėje, matot, yra langelis komentarams, o jeigu reiktų kam vertimo, žinokit, kad jis irgi yra užtikrinamas ir galit pasikeisti renginio kalbą iš lietuvių į anglų arba iš anglų į lietuvių, kai tik jums to prireiks. Taip pat transliacijos viršuje matote nuorodas. Tad būkite aktyvūs. Kažkada Nobelio fizikos laureatas Izaokas Rabis savo sūnui, kuris grįždavo iš mokyklos, užduodavo tokį klausimą: ar šiandien uždavei gerą klausimą? Tai aš tikrai kviečiu jūs užduoti tą gerą klausimą ir padėti mums visiems geriau suprasti ir geriau atskleisti aptariamą problemą. Kągi, dabar noriu pakviesti sveikinimui ir įžanginiam žodžiui Sigitą Rudėnaitę, laikinai einančią pareigas Lietuvos aukščiausiojo teismo pirmininkė ir kartu teisėjų tarybos pirmininkė. Sigita, matau jūs puikiai, tikiuosi netrukus ir girdėsime. Žodis jums.
Sveiki.
Good morning.
Labas rytas, tikiuosi mane girdite. Ar mane girdite mane?
You can hear me well. Can you
Tai
hear me?
labas rytas
So, good
ir
morning to
visi
everyone.
kiti gerbiami konferencijos svečiai, dalyviai,
Conference
mieli kolegos.
participants.
Šiandien džiaugiuosi iš tikrųjų
I'm very
galėdama
happy to
kreiptis
be
į
able
jūs
to
visus
address
Lietuvos
you
teisėjų bendruomenės vardu.
on behalf
Vakar
of the
kukliai paminėjome
judiciary
teismų dieną.
community.
Visi
Yesterday we
laukiam kalėdų.
celebrated the
Ir
day
visi
of the
esam
judiciary,
suvienyti be abejo ir
and we're
bendros
all
mus
stand
ištikusios
united
bėdos,
in
grėsmės,
our
kurią vadinam pandemija, COVID.
global threat, which
Už tai
has a name for
galvoju,
it,
kad
COVID-19
tikrai
pandemic.
simboliškai
And therefore it is
prasminga,
quite
kad šiandien
symbolic
susirinkę
that
visi
we
profesionalai
are
teisininkai
meeting today, all the
nekalbėsime apie
professionals,
tai,
legal
kaip
professionals.
vienas ar kitas teisės institutas
We
išvystytas mūsų
are going
valstybėse,
to
kaip
cover
geriau
various legal
pasiekti
institutes and what would be the most
skaitmeninių
appropriate
technologijų
ways
galbūt
of
prieinamumą naudojimą
utilizing
teisme.
digital technologies to be
Kalbėsime apie tai,
used
kad
at
teisingumas
court in
neatsiejamas nuo
these difficult
žmogiškumo ir
times.
atjautos.
We're also going
Iš
to talk
tikrųjų,
about
valstybė
a very
prisiimdama
interesting
teisę
link between
valdyti
judiciary
prisiima
and
ir
empathy.
pareigą
By
rūpintis.
assuming the role
Šiandien
to rule
kiekvieno
and to
žmogaus
administer
individo
justice, we also have to assume the
teisių, laisvių,
responsibility for
apsaugos,
those who
išsivystymo
cannot
lygis
defend
kiekvienoje
themselves.
šiuolaikinėje
And the level
valstybėje
of
tapo ir demokratijos
judicial
matu.
protection
Lygiai
is
taip
also a
pat
sign
teisingumą
of
šiandien jau
democracy.
nesuprantame vien kaip
Justice is
teisingo įstatymo
understood also
pritaikymą,
not also
teisingo
as the right
bausmės
application
pasvėrimo.
of the law or
Teisingumas vyksta
administration
tada,
of the
kai
good
apginamos
sentencing.
adekvačiai
Justice is
apsaugomos
administered
kiekvieno
when
asmens
every single
patekusio
person
į teismo
has his
procesą
or her
atėjusio
rights
teismo
defended
interesai.
in the
Kas jis
right way.
bebūtų,
whoever that person might be, a child, minor, shared in between two households, or a victim of a crime, maybe a witness of the crime, or could be an accused or a suspect in the proceedings. Not all these categories of people of the judicial system can defend themselves regardless of the causes why they have become part or why they have been involved in the proceedings. These could be psychological, physical, or mental reasons that makes them vulnerable. In every single proceedings, some people become even more vulnerable given the current circumstance, and not everybody can adequately perceive what the interest of him or her might be in these proceedings and what would be the most appropriate way to defend these rights. So, given this situation, we have to be empathic and we have to be reaching out to the vulnerable groups of the society. And of course, we shall not prioritize the interest of the vulnerable groups against the others, but instead we have to ensure a level playing field to all the parties involved in the proceedings. If we are successful in achieving this goal, then we might rightly say that justice has been administered. Of course, knowing what is right is only one side of the story. We are well aware of the people who become litigants in the proceedings, and unfortunately, they are not defended properly. And this understanding of misjustice or misadministration of justice is the starting point. In order to go forward, we have to know how to identify vulnerable litigants. We have to be empathic. We have to be aware of the measures that should be applied to address the needs of this person instead of being humiliated by the system or being held inferior to everybody else in the proceedings. The Lithuanian courts are well competent in this area, and quite a number of steps have been meant in the right direction. There are court volunteers who are working and meeting all the litigants in the courtroom. We have psychologists who are offering their service to victims of the crimes, and these are just a number of steps that have been taken so far. Just as it is in any other area, I do believe that we shall not limit ourselves or be complacent with what we know already, because complacency means going backwards. We should instead share our experiences in order to have, because there is always a room for improvement, and this is, I hope, this is going to be the conference of today, and I would like to promise everybody a very constructive discussion. Thank you very much, the Chairwoman of the Council of Judges, for well-wishing to the judiciary system to be both administrators of justice as well as being the empathic judges. The next person to speak is Dr. Natalija Kaminskiene. She's Director of the National Courts Administration. I do expect Natalija to inspire us for a constructive discussion. Good morning to everybody. Well, I'm very happy to hear so many good and positive notes at the beginning of the conference. Dear ladies and gentlemen, as a way of commemorating or celebrating the Day of the Judiciary, the National Courts Administration decided to host this conference to be dedicated to the most vulnerable groups in the judicial system. And we have selected this topic for a good reason. The entire judicial community are not concerned only by the most efficient court proceedings or adhering to the fundamental principles of law or a good result of the hearings. What we do care as well is a single person who enters the courtroom. Even though the pandemic has slowed down the pace of each of our lives, the courts haven't put on a hold. There are people who are still seeking justice, and quite a large share of these litigants are vulnerable groups of the society. So the path that we have embarked upon in order to help these people was quite a recent step that we made. Luckily, there are some positive notes that we can rejoice on this occasion. We have support staff working able to help child minors. There are court psychologists. There are also court volunteers working in courts who escort court litigants in various corridors of the judiciary. They explain in plain language how the process is going to roll out. They're also standing by vulnerable groups of the society at the time of the proceedings. Are there any other steps that we could help a minor, a disabled person, a refugee, an asylum seeker in the system of judiciary? Do we really address all the needs that they have? How to respond, how to act in one or other situation? So, as you see, I'm coming with loads of questions, and I do expect that the conference and the speakers of the conference are going to answer to some of them. How to inspire a victim of the crime to disclose what has happened to him or her. There are indeed quite a lot of practicalities that need to be addressed, and these issues are just as relevant for the Lithuanian judicial community as it is for our foreign counterparts. And for this reason, I'm very happy to see many experts, distinguished experts from Romania, Norway, and other countries. So I would like very much to invite you to be proactive, ask questions, and to listen attentively to the speakers, to listen to their insights of working with vulnerable groups, to hear the most recent practices applied in Europe, and to discuss together. And in this discussion, to find answers to the relevant questions. I do expect that these discussions and the answers that we're going to get, or at least seek to get, will inspire us for a positive change. So let us be just, empathic, sensitive, and let us protect those who need our help the most. Thank you very much for your attention.
Ačiū Natalijai, ačiū Jums už Jūsų sveikinimo žodžius.
Thank you to Natalia. Thank you for the welcoming word. And now I would like to remind you that your observations and your stories are very much welcome in our section of commentaries. There is a possibility to post your questions in the course of the entire broadcasting. You are very much welcome. And I am extremely pleased to introduce our guest from Armenia, Irina Urumova. She is an international expert in child rights protection in proceedings, and her experience is more than 15 years, and have been working in a huge geographical area from Ukraine to North Iraq, and you are very much welcome to join our conference and share your experience in about special needs of victims in the proceedings.
Dear participants, dear colleagues, I'm very happy to take part in today's conference. As the speaker, the chair has already mentioned, we will be discussing vulnerable groups in courts from the lens of the specific needs of these groups in court proceedings, mainly focusing on practices in Europe and beyond, and main principles of working with these groups. I would like to share my screen to make it easier for everybody. Oops. Okay, I think I did something else. Is it showing?
Wonderful. We could see it.
Okay, great. So yes, I would like to discuss with you specific needs through the lens of principles and European practices. And I will start with the evolution of victims' role in criminal proceedings. The role of the victim has not always been the same. It has been continuously evolving, and long gone are the times when the victim was merely a silent party, so to say, in criminal proceedings, where the process was about the alleged perpetrator, the offense, and the state on the other hand. So the perpetrator versus the state. There is now growing recognition of the victim's inherent interest. And the introduction of support services mirrors this recognition and reflects it, since it is aimed precisely to address the imbalance given the variety of differing needs each vulnerable victim has, and the resulting need to address the imbalance created by these different needs that hold people back from productively participating in criminal proceedings. The recognition started as far back as in 1985, when the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power was adopted, which provides a global basis for the development of victims' rights. It's a non-binding standard, but nevertheless, it's an important one, and it's a first of a kind. The resolution 2005-20 of the UN Economic and Social Council followed, which adopted the guidelines on justice in matters involving child victims and witnesses of crime. So reflecting the recognition that children take a specific place among vulnerable victims and witnesses, given their very specific needs, especially those created by the lack of developmental maturity, and therefore the need for the state to act as a guardian, ensuring that the child's best interest is met. At the European level, the Directive 2012-29 of the European Parliament and the Council that was adopted on the 25th of October 2012 established minimum standards on the right, support, and protection of victims of crime. And it's the first one, albeit of regional nature, but it's the first standard that provides legally binding minimum standards that all EU member states must fulfill to ensure that victims of crime receive the best possible care and support in the aftermath of a crime. And the way forward is charted by the EU strategy on victims' rights, which frames the Commission works through 2025. And it invites actors, stakeholders, including individual member states and civil society, to take action in the areas of priority. But why evolution of victims' role and rights? Probably we first need to clarify what a victim means. Is it the person who has reported the crime, who is participating in the trial, simply the person who has suffered the consequences of a crime? Can the family of a victim of homicide be recognized as a victim? We need clarity on all of those aspects. And it appears that yes, a victim is a natural person who has suffered harm, including physical, mental, or emotional harm or economic loss directly caused by a criminal offense. And this is regardless of whether an offender is identified, apprehended, prosecuted, or convicted, and regardless of the familial relationship between them. A victim falling within this definition is a victim notwithstanding his or her role in the national criminal justice system. And not all provisions of the directive, this is very important, are applied only if the victim has made a formal complaint. Victims who choose not to report a crime to the police also enjoy some of the rights. For example, right to information, which can make them arrive at an informed decision whether or not to report a crime. The person has to feel safe to be able to report a crime, and unfortunately, the more heinous, the more grave a crime, the more difficult the decision to report it unless it's detected. The victim's interest and individual situations come into play here. And we have to realize that it is not directly proportionate to the criminal trial impact. And indeed, a victim who testifies in court does not have a greater interest in the process than the victim who does not attend the trial. However, individual circumstances of each victim have a direct bearing on their expectations, and the criminal justice response needs to be tailored so that to be sensitive to these individual characteristics and inherently flexible. Obviously, the question of the primacy of a fair trial is raised at this point. Does a greater recognition of a victim's role interfere with the right to a fair trial? A legitimate question, but to be able to answer it, we have to first answer the question, what is fairness? Does it imply more than equality of arms? And it appears that the European Court of Human Rights has already given an answer to this question, and in Dorsen versus the Netherlands, the court considered whether it was consistent with the accused's right to a fair trial for a witness who held real fears of reprisal upon testifying against the accused to give evidence anonymously. And the court noted that although the right to a fair trial does not explicitly require the interests of witnesses in general or victims in particular to be taken into account, but their life, liberty, or security of person may be at stake, as may interests coming generally within the ambit of Article 8, and the states should organize their criminal proceedings in such a way that those interests would not be unjustifiably imperiled. Against this background, principles of fair trial also require that in appropriate cases, the interests of the defense are balanced against those of witnesses or victims called upon to testify. In simple language, it means that a failure to recognize the victim's interests while recognizing the interests of the accused leads to an imbalance of power. And this is inherently against the principle of the whole panoply of rights to a fair trial. And the victim's interests do not necessarily coincide with the interests of the state, which again creates an imbalance of power. Therefore, we need a victim-oriented reform, which, as I noted, has already started, but it needs to be further promoted to help redress this imbalance. So the state's legitimate conduct during a trial may, unfortunately, sometimes interfere with the victim's human rights. For instance, a subpoena encroaches in certain cases on a victim's rights to privacy. Is just one example. And there is need to mitigate this interference to prevent secondary victimization. Fortunately, we don't have cases where the interests of the state would be so at odds with the victim's interests that they would not be able to be addressed through victim support services. Hence, we will be mainly discussing how to prevent secondary victimization and empower a victim through creating victim support services that are evidence-based and indeed tailored to the country context, to the and sensitive to the type of a victim and the type of a crime. And here we have to realize that the victim's inherent interest is not limited by the criminal proceedings. It is relevant from the moment the crime is reported to the police, to the moment the offender is convicted, and beyond, to the point that the offender completes their sentence or any post-sentence supervision. And vulnerable victims and witnesses that we will be talking about generally comprise all of these: children by default, all persons under 18 years of age, the elderly, victims of sexual and gender-based violence, domestic violence, trafficking in human beings, persons with disabilities, and other persistently targeted and intimidated victims. And it's important to realize here that intimidated means a lot of things, and it is not necessarily, there is no direct, okay, obviously there is a proportionate relationship between the gravity of the crime and the impact on the victim, but it's not a mathematical formula. And some people may be intimidated to what may seem disproportionate to an external observer, but we have to realize that we are talking about people, psychology comes into play here, and we have to assess each victim upon intake to realize to what extent they're affected and to tailor the services accordingly. We cannot expect all people to be helped equally if we adopt a cookie cutter response. Victims' rights include the right to understand and be understood, including the right to proactive assistance and the right to be accompanied by a support person, the right to receive information from the first contact with a competent authority, the right to receive information about their case once it has started, a right to interpretation, translation, right to access victim support services, the right to be heard, and rights in the event of a decision not to prosecute, including an entitlement to ask for a review of a decision not to prosecute. And child victims and witnesses should enjoy the entire spectrum of these rights, and their age should not affect the degree to which they enjoy the right to be treated with dignity and compassion, the right to be informed, although of course here there will be specifics. The right to be informed in a child's case needs to be understood as the right to be informed in a language that corresponds to the child's age and developmental maturity, the right to be heard and to express views and concerns, the right to privacy, which is more important in the case of a child and may include both restricted disclosure and restricted attendance, and the right to be protected from hardship during the justice proceedings, which includes the assistance of a support person throughout the justice process, as well as access to child-friendly facilities, such as Barnahus, for example, which is now a model adopted throughout the European Union and actively promoted beyond it, and that aims to create a multidisciplinary model for children to be processed through from the beginning through the very end of the criminal proceedings, and where children, for example, if they need to be interviewed at the pretrial stage, they would be interviewed once in the same setting to prevent both secondary victimization through repeat interviewing and, very importantly, prevent any distortion, any interference with the integrity of evidence of the child's testimony that may result from repeat interviewing, because the child may change their story, not because they want to lie, but because they're simply confused. And here we have to understand the right to understand and be understood includes providing victims instructional materials that would explain their rights and duties and what to do if they feel threatened or intimidated. As already mentioned, children should receive information adapted for age and developmental maturity, and there needs to be accessibility for people with various kinds of disabilities. And this extends to both print and video multimedia content that is also ideally included in instructional materials. The right to access victim support services takes many shapes. In some EU member states, there are special units or services that are geared to provide support directly during trial. For example, in the Netherlands, there is a figure of a case coordinator. In Sweden, there is state-guaranteed access to witness support services at all district and appeal courts. And in France, the government are supportive to the setting up of a framework of external NGO actors, but they run offices for victim support throughout the court system. The right to be heard also takes many shapes. Victims have varying scope to express the impact of the crime and the resulting harm, also very much depending on the type of system in place in each state. For example, in Ireland and in the United Kingdom, victims are entitled to make a victim impact statement or a personal statement. In some countries, this is expressed as by giving the victim the status of a party to the proceedings, or even a private party prosecutor or accessory prosecutor. In Germany, there is a figure of Nebenklage, a subsidiary prosecutor, which combines all the three approaches. In each victim acting as Nebenklage is entitled to legal representation, both before and during the proceedings, may examine the case file, suggest factual investigations, ask questions of witnesses, make closing statements, be present obviously throughout the trial, and file an independent appeal against the judgment. Which brings us to the next question. What happens if there is a decision that no prosecution should take place altogether? In some countries, there is an express right extended to victims to seek a review of decision not to charge, discontinue, or otherwise to terminate proceedings. So a review of a decision not to prosecute. And reassessment of the victim's role means that also recognizing their expectations, because victims are unlikely to feel adequately informed and heard, regardless of how much you try, if their expectations are not considered legitimate. So we cannot afford a mismatch between the expectations and the reality. We need to ensure clarity about the role of the victim and their applicable rights and limitations. There are limitations, but the person has to be aware of them from the outset. And setting clear parameters for the victim's legitimate expectations also helps. If there is clarity, there is also better cooperation. And it's important to remember, as I already mentioned, that victims' expectations and perceptions of the criminal trial process differ. Their needs are complex and variable, and therefore we need a comprehensive end-to-end victim support service that would take in the victim at the very beginning, assess their specific needs, help set the parameters for legitimate expectations, and lead them to the trial stage, because intervening at the trial stage would in most cases be too late. And this means a comprehensive end-to-end service means a victim-centered service that is contextually specific and appropriate, culturally and physically accessible, and driven by the needs of individuals impacted by crime and violence, which include both primary and secondary victims, as well as broader communities affected by crime. And it's important to remember that at intake, each victim is assessed for the needs that they have and protective factors alike, which means the factors that help them, that can be used to help them in coping with the aftermath of a crime. A thorough needs assessment usually involves, well, depending on the victim's needs, obviously, shelter, housing, culturally appropriate food, seasonally appropriate clothing and shoes, language needs, immigration, criminal, or other civil legal support, court accompaniment, advocacy, transportation support, medical care, language courses, substance abuse treatment, mental health services, public benefits, crime victim compensations, links to culturally specific or faith communities, employment training, and help to victims' children or other dependents. And victim safety is an important component of meeting victims' needs. But we need to understand, again, that victim safety is more than here and now. It is, again, something that is important from the very moment the person mulls their decision whether or not to report a crime. So they need to be to receive information that can make them help them make a decision if reporting a crime would be safe in their case. And once a person has been referred to the support service, they need to be continuously reassessed. The victim's safety needs to be monitored and tracked through such ways as working with the victim support service to collect feedback from victims, follow-up mechanisms to see if victims feel safer following police intervention, and throughout the proceedings, detecting instances of reoffending that go unreported to police, detecting and assessing breaches of protection orders, for example, in cases of domestic violence, and monitoring attendance and completion of perpetrator programs. So there are different ways to monitor both at individual victims level and at the systemic service level. Thank you, and I end my presentation here, and I stay open for your questions at a later point. Thank you.
Thank you so much. Thank you so much, Irina. Thank you for so comprehensive presentation. Later on, we will have more deeper and more broader discussion. Thank you. Ačiū. Ačiū mūsų viešniai iš Armenijos ir noriu judėti prie kito mūsų pranešimo, primindamas, kad jūs turite galimybę
from Armenia. I would like to remind you that you can always ask questions or raise your questions using the functionality at the top of the screen. And I would like to invite our next speaker, Kristina Mišinienė, the head of the Center for Combating Human Trafficking and Exploitation in Lithuania. She's a master in social sciences. She has quite an extensive experience of working with socially vulnerable groups of the society. She's been actively involved in providing support to victims of sexual violence and human trafficking. And since 2017, she has been heading the Center for Combating Human Trafficking and Exploitation. So thank you very much, Kristina, for joining us, and we do expect to hear you well. Good morning to everybody. Thank you very much, the organizers, for picking such a valid topic of the conference in such difficult times, especially when nobody is perfectly aware of or certain about our future. So it is a very timely topic chosen for today's conference, and I do expect that the discussion that is going to evolve throughout the conference will unveil hopefully some innovative ways of dealing with the situation at hand. I was listening very attentively to the speaker, to the previous speaker, and I was marveling at the vast majority of really good instruments on the European level, how to address the needs of the vulnerable groups. And in particular, I mean when these groups decide to stand as witnesses in the proceedings. And this is, I believe, one of the major challenges, at least for our country. Who is going to implement all these commitments, which may sound nice on paper, but it takes a lot of effort to implement in practice? I, as being a representative of the NGO sector, who've been working for so many years with vulnerable groups of the society. So, speaking from my perspective, I would like to encourage you to take the inventory or stock, to take stock of what instruments we have at the moment and which of them we are implementing. I would like to focus on, in my presentation, of what I know best, speaking from my first-hand experience in working with victims of human trafficking. And the experience that I would like to share with you has been built by working with this vulnerable group of the society. Just as the previous speaker mentioned, victims of human trafficking cannot be simply copied and pasted. Successful instruments working with this group cannot be copied and pasted to other group of vulnerable members of the society. And now I would like to share my screen with you. Hopefully this is going to work well. I expect the confirmation from the moderator that you can see my slides on the screen. So to start my presentation, I would like to give you some statistics, or where do we start from, what is our starting point and who we are. Well, we have quite an ambitious name, which is the Center for Helping People who have fallen victims of human trafficking or have been victims of abuse. We have field offices spread all across Lithuania, and our core activities are activities on the field, so to speak. We are on an active search for victims, trying to motivate them to come forward and to cooperate with the judiciary. And we're also actively involved in helping these identified victims of human trafficking in all the stages of their reintegration into the society. As you might know, people who decide to cooperate with the judiciary by deciding to cooperate, they make a life-changing decision, because in Lithuania the proceedings may last from 2 to 3 years, and you might know that such cases usually move all along the stages of the judicial proceedings and all courts of all instances, and there may be indeed quite a lengthy process. So you may well imagine that a person who has chosen to cooperate with the judiciary, maybe initially having one level of awareness or the reasons for cooperation, as time goes by, this decision to cooperate may change. And the statistics that you see on the screen illustrate how many people benefited from our support. And these figures, for us working for the NGO, they're indeed remarkable. The remarkable ones, because the social workers are helping out the victims, are doing lots of preventive activities as well. And these figures of the people who cooperated with the judiciary, they are quite big ones. I'm once again repeating myself. And these are people who have fallen victims of human trafficking, prostitution, sexual abuse, and pedophilia. And these categories of victims are not very active when it comes to reporting of a crime. They're not so willing to become witnesses in the trial. And as I've just mentioned, sometimes a decision to be part of the proceedings is sometimes taken on their behalf. A victim of these crimes who has decided to cooperate with the judiciary, he or she is responsible for the decisions taken. And without an active involvement of such a victim, we cannot seek justice. And some of you might think that these figures are indeed not something to be worth boasting about, but I would like to remind you once again that we are NGO, and given our limited resources, these figures quite illustrative. And you have to be aware that these victims would not be coming and knocking on our doors and saying that, you know, I have fallen victim to human trafficking. So it takes a lot of effort to identify such victims, to locate them, and to help them seek justice. And therefore, at the start, once these victims decide to go ahead with the prosecution, then a number of other actions are set in motion in the system of the judiciary. So when it comes to the well-being or the psychological well-being of the victims once they become part of the judiciary, I would like to note on the specificities of this category of witnesses, what makes them special compared to victims to other forms of crimes. So what are these risk factors? Before falling a victim of human trafficking, a person is usually vulnerable, belongs to a vulnerable group of the society. And from the cohort of the victims that we're helping, we see that there is a group of features, personal features, which lock them in this vicious circle. And sometimes not a very politically correct term might be used when it comes to describing this category, such as dysfunctional or people who cannot function properly in society. So what are these sources of vulnerability come from? These are usually persons with no or very modest education, children, minors, or people who live in conflict with their family members. Poverty and economic factors are usually the underlying category, which is common to all victims of human trafficking. So this is our major conclusion that we make, that people coming from very impoverished backgrounds, they have a higher likelihood of becoming victims of human trafficking. And if you add conflicting environments within a family circle, then you already have two main factors which might trigger a person to seek a way out, and usually they may fall into the net of human traffickers. So we see here from our work that usually human traffickers, they target vulnerable groups of the society, mentally ill or physically disabled members of the society who could also fall victims to human trafficking. These are the persons who sometimes are not capable of appreciating or realizing the true essence of a certain situation. Indebtedness or is yet another factor which makes people vulnerable. And these are not debts that victims might have to in respect to human traffickers. And by the way, this is used as one of the techniques of how to keep the people in the net, claiming that they owe you something. Usually, quite a lot of vulnerable people have taken the so-called very fast credits. This is a word-for-word translation of what we have in Lithuania. Basically, these are credits which you might take without having anything to mortgage. And in this way, a person may take a credit of 1,000 or 2,000 euros, but have nothing to return this debt from, and therefore people become indebted for life, basically. Lack of foreign language skills is yet another sensitive factor. So the situation hasn't changed compared to now or compared to 20 years before. People who have no foreign language skills, if they are thinking seriously about taking a job placement abroad and they do not have foreign language skills of that particular country, that makes them exceptionally vulnerable. Another characteristic which describes victims of human trafficking is victims of violence or domestic violence or sexual violence. And these people are looking for any possible way out. And they usually then take the first option or offer that comes their way. And by this, they fall into the net of human traffickers. Gender-based risk. We also see in some forms of abuse that gender is quite an important risk factor. When young women are exploited in prostitution, and these are mainly young girls who are used in prostitution. But sometimes young men too may experience gender-based risk. The last category of risk factors belongs to migrants. Since we have opened our borders and we do not have any safeguards to ensure the rights of migrant workers in practice. In theory, everything might look quite nicely, but when it comes to the reality, we see that migrant workers are vulnerable in that they do not have language skills, they do not have a social network, social support network. They're almost in all cases they're on their own in a foreign land, working as a migrant worker. Now moving on to the risk factors. At the time of exploitation, these factors are similar to all forms of abuse and exploitation. Sometimes migrant workers, they get much worse pay than was initially promised, or their freedom of movement is restricted, or they become victims of various forms of violence. If at the time of recruitment there was like a mealy-mouthed way of luring a person or taking an offer, so very quickly, once this person is in a foreign land, outside of reach of the Lithuanian support services, then this pleasant way of talking ends. And usually, such human traffickers, they use various physical extortion methods in order to subdue a person who has become a member of their network. And therefore, it is very difficult to help these people to escape from this network. And then usually these people are afraid of getting free from the network because they owe quite a lot for cellular phone, for being given accommodation or any food on the table. And these people do not realize that somehow they have this misconception conception of fairness, that they believe that they do owe the human traffickers a certain amount of money, and it is for that reason that some of them, especially with lower mental capacities, might believe that it would not be right for them to seek escape from the network because they were given job, for instance, because they were given a telephone number, or for a very simple reason. And sometimes victims of human trafficking, they tend to believe what they hear, and if they hear that nobody is going to help them in a foreign country, then they tend to believe this. And for us, well-educated members of the society might think that it is ridiculous how you might even believe such a nonsense. Unfortunately, victims of human trafficking, they are low-educated or have no educational background, and they have a very low self-esteem or misconception that nobody is going to take care of you. You have to fend for yourself, basically. You are on your own. And therefore, it is very important to know that trust in the judiciary, trust in the support services is a very important factor which might encourage a victim of a human trafficking to cooperate, but later on they might change their decision very quickly. When we have a person who has already escaped a human trafficking network, it is very important for us to cooperate with this person, not to leave him or her on her own, because these people are already vulnerable. It is very important to discuss with them some psychological aspects. These are the fundamental principles which make it possible for us to cooperate with this person. We have to realize what were the root causes which pushed a victim of a human trafficking to become a part of this network, to tolerate any physical abuse or sexual abuse, or perhaps they are hiding something, they are not telling all the story. Maybe they are not willing to get any assistance at all. I think that we have to do our best in order to identify the answers to these questions, and we have to go deeper, to look into the psychological consequences of abuse. We hear a lot about physical violence, but this type of violence is becoming less frequent. Most often, we might see some signs of beating with cords or with belts, and we had a person who was held tied up to a radiator in order not to escape. So there are some physical consequences of abuse suffered by a person, and usually it is beyond any discussion. It is self-evident. But when it comes to hidden consequences of abuse, then we might identify quite a large group of them. These could be infectious or contagious diseases, hepatitis, tuberculosis, HIV. Quite a large group of our clients are HIV positive, also addicts of various substances, abusing various substances. And these groups present very serious challenges for support services. When it comes to psychological and emotional violence, this type of violence is not easily visible. What we could see is some form of behavior, and therefore ability to recognize these symptoms testifying the psychological emotional violence, such as anxiety, fear, or loss of sense of security, denial, or distancing himself or herself, or even shame. We have to realize that if we fail to address these symptoms, they may then evolve into serious mental or physical disorders. And I have to note, unfortunately, that in more than half of our clients, we identify post-traumatic stress disorders. And because such victims are imprisoned in their previous experiences, they cannot move forward. They develop depression, anxiety, or they have suicidal thoughts. And even though the time goes by, these people are locked into their psychological, mental dysfunction because they treat every single event as it happened only yesterday. Suicidal attempts may sound strange in this context, but for us it's nothing extraordinary, because at the time of exploitation there may have been a number of suicidal attempts to cut the veins, including men or women alike. So not only women exploited in prostitution, but also men who were involved in crimes. We saw hands having symptoms of suicidal attempts, of cutting themselves or inflicting personal harm. And we saw some symptoms of routine self-harm in many of such clients, where all their bodies were covered in markings of various suicidal attempts. So indeed, there were horrific stories that we have witnessed. One of the symptoms of post-traumatic syndrome or disorder is the loss of memory or some tricks of the memory. So for those of you who may have worked with such vulnerable groups of society, you are perfectly aware that a victim sometimes might have such disorder as selective memory. When a victim selects what she or he wants to remember or doesn't want to remember, or some misleading information that you may get sometimes from such testimonials, when some of the experiences that have nothing to do with the events are all of a sudden crop up during the investigation, and they may sometimes develop into the situation where we might even believe that a victim is trying to hide something or that he or she is lying. But these are objective status or objective root causes which might explain such a strange or abnormal behavior from our point of view. And we hear quite a lot from the law enforcement officers that sometimes victims do not even regard themselves as victims. Well, I would be very cautious when it comes to the so-called Stockholm syndrome. I believe that all the people have the inherent sense of justice. All people understand what has been made wrong in what wrongs have been inflicted upon them. But when such an exploitation lasts for longer stretches of time, then it creates a certain mode of behavior. If exploitation lasts for a lengthy period of time, involvement in the crimes or prostitution, and there is simply no any other way of survival but to come to terms with the current situation, we sometimes believe that a victim should be someone showing a very active signs of fighting for himself or herself, or not coming to terms with the current situation. Unfortunately, there is a very small proportion of those who indeed are trying to fight back. We might even discover that there was a telephone always lying on the table, or the doors would never be locked in that apartment, but the victims would not try to escape. So an explanation to such a strange behavior could be seen also from the previous background, as well as the general attitude to stress. we living in a safe environment might believe that we would be acting differently, but we're perfectly aware that there are different ways of how to respond to stress. Some might choose to act, others are stupefied, and they are absolutely incapable of doing anything to save them. And this is only natural. So it comes to have a certain degree of legal literacy to help this person to perceive himself or herself as a victim, and in order to try to seek justice. Most of such victims would never regard themselves as victims. They would not even call themselves victims, or they would not be willing to verbalize their sufferings. And we understand that you have to be able to express your sufferings. It is not sufficient in a courtroom just to be crying and not telling anything. Then in practice, you're not going to prove your case. You have to be verbal. And unfortunately, we often hear when victims decide not to go ahead with in the system of justice, and they decide not to seek justice. They refuse any help, and this self-denial that I don't need any help, that everything is fine with me, it is quite a shockingly widespread. And we as social workers, we have some strategies how to deal with such people. It is not sufficient to approach a victim of human trafficking only once. Perhaps the state of mind of that person at the time of the first approach is the wrong one. We have to wait, to sit and wait for an appropriate moment and to approach this person once again. So the mental state of mind has to be appropriate for this person to look at the same situation from a different angle. So there are a number of practices that we have to use as social workers. There are only very few who, after repetitive approaches, would still refuse any help. So if we had more resources, more social workers, if we could approach these people much more frequent, I believe that eventually they would realize that they do need help. The majority of victims of human trafficking are referred to our NGO by the law enforcement officers. And therefore, our cooperation with them is on a case-by-case basis. And in our field of activities, there is a very low freedom of maneuver for the victims. And it is very rare that human traffickers are already behind the bars, and these victims are afraid of any reprisals, that perhaps they're going to be persecuted, not in the judicial system, but by the accomplices of the criminals. And it takes indeed a lot of time to realize that they do need help and that they have to seek justice. So at the start, they have to, first of all, to make up their mind to be part of the justice system. And now I come to the core part of my presentation and why I'm here today. That currently we have a litigant in a court proceeding who is a victim of human trafficking, and I can illustrate my talk with a specific case at hand. You always have to seek feedback and to see if what you do is relevant. And I do expect that what you hear is interesting and relevant for you. Unfortunately, we cannot change our mode of conference today. So what are the expectations of the victims of human trafficking in court proceedings? Or what are the core principles, how we modulate our behavior at court? I believe that we can break them down into 4 major groups. So first of all, a victim, and when I mean a victim, I'm talking about victims from my field of activity. So I'm talking about victims of human trafficking only. But you might discover some similarities also which could be relevant for other categories. So the principle number 1, respectful behavior. And you may believe that it is self-evident or self-explanatory, but a victim who is a witness in a court trial is only a tiny fragment in the overall system of judiciary, and there are a number of preconditions which do not allow this victim to become a major axis around which all the judicial proceedings would go around. But at least we have to find the ways how to demonstrate a victim that his or her experiences matter, that his or her fears are taken on board, that inability to express themselves verbally are also taken on board without disregarding their testimonials because of the lack of these verbal skills. During court hearings, what I have noticed is that whenever witnesses are giving their testimony, sometimes the suspects or the accused, if they are sitting in a very small courtroom, which are not intended for a large-scale proceedings, they're very outspoken, they're very vocal, and instead of responding to one another arguments, but they are trying to intimidate the victim sitting in the same small and compact courtroom. And therefore, this behavior with the judge and the behavior of the accused or the suspect in a courtroom, we sometimes feel a very disrespectful behavior of suspects towards witnesses. I do understand that judges sometimes turn a blind eye to such disrespectful behavior towards witnesses, but this theater that sometimes goes on in courtrooms are not meant for a judge to impress or not for other parties to the proceedings. This theater is meant to show off to the witness that we are the ones holding the reins of power here. And the judge, when it comes to the judge, he or she may be a party to a number of such theater performances throughout the day. But for a witness, for a victim witness, sitting in only one court proceeding and being intimidated or downplayed by the suspect is not the best experience ever. The second major principle, which has to be ensured, and it follows from various recommendations of the EU, is security, both physical and psychological. I do realize that we can talk quite a lot about the needs of the victims. Unfortunately, we have to realize that nobody is going to rebuild court rooms from scratch, and we will still have to work in the same court rooms as before. We who escort victims to a court have to be very vigilant in trying not to meet a suspect in the corridor with a human trafficker. We are seeking a hideout, be it in restrooms, be it somewhere in the smaller niche corridors, and we're always waiting until the last moment. Unfortunately, it is inevitable we meet the suspects just immediately before the hearing. Sometimes the suspects are escorted by the police during the hearing already. But we as people who are escorting witnesses to a court hearing is quite a challenge. How to help this person not to meet a suspect face to face or a crowd of criminals standing in front of a courtroom instead of hearing all those despicable remarks thrown into the face of a victim. Unfortunately, this is an inevitable situation as we have, and having individual waiting rooms for victims is still wishful thinking, but not a reality. We have to insist on being given access to individual waiting rooms. Sometimes the prosecutors themselves do not see any problem in waiting and staying in the same space because they have been living maybe or working together for the past 2 years. So prosecutors come up with very strange responses to that. Sometimes there are no such waiting rooms at all equipped in courthouses. And there may be some technician coming into a certain room, or some microphones are not working, and instead of giving a remote testimony, witnesses are then escorted to the major courtroom to give evidence. And the victim who comes with a certain expectation of being given the right to give testimony in an individual room through a remote equipment, unfortunately, all of a sudden, due to some malfunctioning of the technologies, they are pushed into the main courtroom and give their testimony. And sometimes victims might feel that it is them who are being prosecuted in that hearing. And unfortunately, time is running fast, as I see. Indeed, it's so much that I could talk about what it means when the court hearing takes place at 9 o'clock in the morning in the capital of Vilnius, and the victim lives in Rokiškis, and the social worker who is meant to accompany this victim lives in yet another corner of Lithuania. So sometimes this travel to the court house is taking place during the night, because this waiting is sometimes indeed a torture, or it's like sometimes we also have cases of suicidal attempts when a victim on the eve of a court hearing all of a sudden disappears, or suddenly children fall sick and they're taken to hospitals, or suddenly they're not granted leave from their work. So this psychological insecurity sometimes might play a role and might bring additional issues to the process. So you may not realize what is taking place. All it takes for the victim is to tell the truth. This is a sensible person talking, but unfortunately there are some psychological factors which are much more powerful here. It is very important for victims to know of what is taking place, and this is where my efforts are the most. I believe we are running out of time, or am I wrong, or am I right? Okay, I will try to squeeze my presentation into 2 minutes. Somehow I thought that I was speaking very concisely. So information. Providing information is very important. Even decisions which are not favorable for them, people still take them and they accept them as long as they understand what is going on. And it is being stressed now more often in courts, and some time is given forgiven for that, and we're very much thankful for that to courts and to all litigants, that it is quite understandable that you have to make the victims and witnesses aware of the whole proceedings. And unfortunately, I have no any further time to tell my story, so any room for improvement for the future. I do expect that social workers, socially vulnerable persons account for a very large proportion of victims of human trafficking due to their educational background, for instance, and something which comes as self-explanatory or self-evident for a person with a university background. A person who has no educational background or very basic education have a completely, maybe a distorted picture of the reality. And we have to allocate much more time in order to raise the awareness of these people. And we have to give credit to post-traumatic behavioral patterns of victims, and being more aware of sometimes strange behavior of victims might help the judges, might help the prosecutors to get the better picture and better understanding of the case at hand. And to complete my speech, I wanted to show our clients who are victims and witnesses in court. So thank you very much for your attention. And to sum up, judges and assistant judges and all the court volunteers are, in a way, indeed helping us a lot. And the very way of your willingness to talk and coming forward with your challenges. And we do understand that you also have your fair share of your problems. But the very fact that you invite us to speak and the very fact that you want us to tell the side of the story from a vulnerable people, we are very grateful for that, and thank you very much for your attention. Thank you very much, Kristina. Thank you for helping us to realize the perceptions and the feelings of victims of human trafficking. And one German sociologist said that making a problem or being outspoken of a problem is an inseparable part of problem solution. So as long as we become outspoken, this is already one step in the right direction. And we're going to seek for any other possible ways of improvements in the right direction. And now I would like to hope that we will hear many more insights of what we have to do in order to make vulnerable people feel at ease in court. The next speaker is Vladimiras Sinyovas. He is the legal advisor to the United Nations High Commissioner for Refugees. Vladimiras has 22 years of legal experience in the area of asylum, by working in the UNHCR office as well as in the European Commission. In the European Commission, he was in charge of the new version of the refugee directive, and at present he is the legal advisor to the UNHCR for the Baltic states. Vladimiras, I can see you perfectly well and quite in good mood, and I do expect that we are going also to see and hear you perfectly well.
Thank you very much. So I'll try to see if everything is working. And my traditional question, can you see my presentation? So, okay, I can start. So my colleagues, good morning. My task today is to discuss different challenges that asylum seekers face while participating in asylum granting procedures and maybe discuss some homework that member states have to complete in order to ensure due protection to asylum seekers according to international and European and Lithuanian legislation. So the organizers of the conference asked me to formulate a question that perhaps you can answer, being the participants of the conference. The question was whether the special procedural guarantees should be ensured mutandis mutandis to vulnerable asylum seekers in legal proceedings. So, to a large extent, those remedies and those protection measures are applied in administrative procedures. That is, in the stages when the migration department examines the interviews the asylum seekers. But since our challenge is to have some kind of problematic discussion, I would like to ask you to think about the mandatory guarantees. So the question is whether those guarantees should be ensured in the appeal stage. That is when the appeals are examined in courts. The position of asylum seekers is very special. There is an international case law. It has been recognized that asylum seekers are attributed to a vulnerable group of residents. This has been already formulated by a European Court of Human Rights, and it has been concluded that asylum seekers are vulnerable group of residents. The Court of Justice also mentioned that that asylum seekers encounter different difficulties of personal or material nature. Why? But our organization, that is the board, has concluded that frequent asylum seekers suffer from traumas. Can you imagine the condition of people leaving Syria and people, what their trip looks like from Afghanistan to Lithuania, let's say, and we know that this has been mentioned by many speakers that the Mediterranean is one of the largest cemetery in Europe, having in mind how many lives were claimed by the sea on their trip from Asia to Europe. We also know that when a person arrives to Lithuania and files an application, such person is assigned to undergo the asylum procedure. So what we look at is whether the claim that the person is endangered is reasonable. And that's why the public authorities examining such application, my colleagues that work in this area know that that procedure is very particular. It is very different from administrative procedure. It is the situation when a person arrives to Lithuania and wants to get a job or wants to get residence permit on the basis that he is going to work in Lithuania. So this procedure, although it is implemented by Migration Department, is very different from asylum seekers procedure. The persons that manage to leave their country will never find any confirmation from the abusers in their country of origin. That's why very often nearly the only evidence in the procedure is the story by the person itself. So that's why we here speak about the special evidence requirements, like the benefit of the doubt, then and all those special conditions are applied because the position of an asylum seeker is very special. That's why we need to apply very special procedure to see whether they are really refugees and whether they can be entitled to the rights that are granted to people who are refugees. One way or another, the procedure provides for their duties, and their essential duty is the duty to support your story. That is to provide comprehensive information and explain why the person is facing danger. That's why the person is required to remember and to tell the main circumstances on the basis of which he is filing his application. The Migration Department applies the so-called reliability assessment criteria. Those criteria essentially means that in order to accept such story as an evidence, the story must be very detailed, consistent, complete, not contradictory, and also be consistent with other criteria. And the main challenge when we follow this principle is the point that different asylum seekers have different possibilities to undergo this procedure. It is quite possible that some asylum seeker in Lithuania who had never suffered from any violence, but he was suffering from different factors that affected his ability to communicate with the officers and to tell the story. There are some very general factors, and psychologists have said that it is very unlikely or very difficult to expect that a person can tell the story in a comprehensive manner about the events that took place some couple years ago, because their memory is operating in some funny ways. But nevertheless, the person is required to tell what happened. And what happened in their country of origin that forced them to leave the country. Let's say this is just an incomplete list of different categories of asylum seekers. Let's say a woman who is illiterate, who has been consistently raped by local military group. So she arrives to Lithuania and she has to explain to the officer the reasons why she left her country and why she filed the asylum. So that is to tell the story to the man wearing a uniform, or maybe a woman, that would be much better. So that would be very challenging. And today I want to speak about such challenges and what needs to be done to ensure that this woman does not stay silent during the entire asylum procedure, because if she fails to tell her story and to explain in what kind of threat she's facing, the final decision will be negative, and she will have to go back to her country of origin, maybe go back to her country of origin and again face the same threats, the same things that she was running from, and arrive to Lithuania seeking asylum. That's why we, and that is the case law of the European Court of Human Rights, is that some asylum seekers may have additional needs. The European Court of Justice speaks about the particularly vulnerable asylum applicants. European Court of Justice speaks about asylum seekers that require special procedural guarantees. So a lot of material is in the asylum procedures directives, which says that the person's possibility to exercise his rights limited because of personal circumstances. The personal circumstances are listed in the preamble, in the resolution part of the asylum seeker. One of them is, one of such reasons is related to gender. It is sexual orientation, disability, diseases, mental disorders, rape, and physical or sexual violence. So the person is suffering from the outcomes of such actions. The list is also included, although it's not a finite list, in our law on the legal status of asylum of the Republic of Lithuania, and the main principle, which perhaps is worth speaking about, that according to European law and the asylum directive, it is the positive duty of the member states to assess whether the asylum seeker have special needs. And in this context, I need to speak about three main aspects. That is, first of all, it is the member states' duty to assess whether the person has needs special guarantees. Article 24, paragraph 1. Also, the directive speaks that member states should endeavor to identify applicants in need of special procedural guarantees before a first instance decision. So that if a person later on, at a later stage, goes to court, so his case file already should contain the assessment about the need for special procedural guarantees. It should make clear whether the person's ability to speak, answer questions are limited in some way or restricted in some way, and what kind of procedures or safeguards such person might require and needs to be ensured. And the third aspect is speaks about continued assessment and continued provision of guarantees, because if it becomes apparent at the later stage of the procedure that the person has some special needs, that also needs to be taken into account. The second challenge is that certain circumstances that require special procedural guarantees are not that easy to determine. Some court torture may be exercised in a way that leaving no sign. Maybe some signs can be not that easily detectable. Some maybe can be detected by marks on human body, but there are some other ways that don't leave any marks, and the person cannot remember, person cannot explain, and that is a very serious challenge. So that's why the first challenge is to identify such person. And that's why we speak about a mechanism, remembering the positive duty of the state to identify persons with special needs. This kind of mechanism in Lithuania is already present. It is not perfect, but my colleagues have been working in this asylum area. They know that our Ministry of Internal Affairs has a description that discusses different methods to identify certain victims and how to see that. So that speaks about the primary interview when a state border guard or the migration officer that accepted the application during the primary interview has to assess whether the person is vulnerable. If that is possible, if such characteristics can be identified, this has to be already recorded. That is a very, very preliminary assessment. The second stage is the integrated assessment that involves psychologists and medics, and that stage evaluation must be carried out within the acceptance system that would be our Foreigners Registration Center in Perednis. So that goes into a complex assessment, and during that area of assessment, during that stage of assessment, the material of Migration Department is taken into account. And the third stage, as the stage clearly concludes that the person is vulnerable and has difficulties in participating in asylum procedure, and that's why it is necessary to go back to the second stage and see the needs of the person into account. This year, the Lithuanian Supreme Administrative Court took one decision, which I will be referring today for several occasions, and the court concluded that during the primary interview, the applicant failed to produce certain data. And the court also concluded that certain data had to be specified during the second stage. But I fully agree with this opinion that the principle is that vulnerability is to be assessed during the entire procedure. Sometimes if the person fails to produce sufficient evidence, evidence, it can be produced later. And if we conclude that the person had been tortured, or the person feels difficulties in answering questions to make his participation in the procedure meaningful, then the question arises, what's next? And the answer is in the directive. The directive says that the state has to provide sufficient assistance to ensure that the asylum seeker can properly participate in the procedure. Also, the directive says that such applicants should be provided adequate support, including sufficient time, in order to create the conditions necessary for the effective access to procedures. Adequate, sufficient time is a very important aspect. That says that rushed procedure can cause harm. In my opinion, it is also set forth in the description of the asylum seekers of the Ministry of Internal Affairs of Lithuania. The description speaks in a separate section, maybe not in the main section, speaks about the procedural guarantees to vulnerable asylum seekers. So I would urge lawyers. I know that there are lawyers in the audience that apply that description. So I invite and I call you to see not only on the main text of the description, but also its Annex 3, because that specifically speaks about the vulnerable seekers. I will speak about some of those guarantees, but my intention is just to use this example, one example. I will be speaking about people who had been suffering from rape, torture, or some physical or sexual violence. The challenges that such people face are related to several aspects. First of all, there is a physical aspect to it. When a person has to recall once again of what he was going through and tell what he has coping. So a coping mechanism is triggered. There is some kind of adaptation there, because that is a very painful memory for a person. And we know that in such cases, interviews can trigger some memories, and the person can go under secondary traumas, because the person will again go and will undergo this negative experiences, and this will create additional difficulties for us to understand what happened to the person. Then concentration disorders, feeling of guilt and shame, also the person's gender and cultural. The asylum seekers currently are present in Lithuania are from different countries, very often from our religious countries, and they have significant difficulties, so just not impossible for them to speak about some intimate matters, let's say, like how a woman was raped.
Galėtų pradėti apie tai pasakoti, bet tos namų darbus reikia atlikti. Apie juos aš dabar kalbėsiu. Nuo ko reikia pradėti?
We need to make
porą trejetą minučių iki jūsų pranešimo pabaigos, tiesiog mano darbas discipliną prižiūrėti, prašau.
So you have another 3 minutes. Unfortunately, Vladimiras, you have somehow to squeeze your presentation. So allow me to concentrate more. So the appropriate conditions of exception. First of all, you have to provide social, medicinal, and psychological support in such cases. And unfortunately, we do not have any time to talk about procedures of the expedited procedures, for instance, which is, by the way, possible according to our national law. Then there is no such possibility for preparing themselves for the proceedings is very scarce. Support and guarantees. Social workers have to help the person to participate in an interview, and therefore all the guarantees are already provided for in the annex to the description of the procedure of the Minister of the Interior. Interview. By the way, here we come to the core element of the asylum-seeking procedure. Interview has to be performed in appropriate conditions, just as it is said in the directive. So what are these appropriate conditions? The good appropriate environment. Basically, are there any signs of power in the premises? Is it more or less of a private interview or a state approach that could be felt? Body language, an atmosphere of trust and security, and provision of any necessary breaks if a person needs them. At the beginning of the interview, there shall be enough time allocated for building this atmosphere of trust. Perhaps a woman, a victim of a sexual violence, she has never talked about this incidents to her husband. So how can you expect her to become all of a sudden outspoken to a police officer? So necessary time has to be allocated in order to build this trust. And empathy, I believe we have heard a number of times this important word. So we have to use a very impartial and objective language. We have to avoid any prejudices. And empathy is the key in order to build trust of victims of any type of violence in the judicial system. And yet more aspect which is worth mentioning is evaluation of facts. And I have come across a number of decisions when it is quite obvious that a person is a victim of a certain trauma or some mental disorder, and the decision of the court says that this person most probably is lying because he or she is inconsistent. So it is quite an obvious disregard of the human rights, and the European Court of Justice has a very has been very outspoken in this regard, that the human rights of a person suffering from a mental disability has been violated. Such a person sometimes is not capable of making use of expedited proceedings. If the person is speaking indeed quite in a confusing way, it is a signal that this person needs a certain time of adjustment. So we have to answer ourselves a question: should a court hearing go ahead regardless of the situation or the mental status of a person, or should we afford enough of time for this person to feel at ease? Unfortunately, I do not have time to giving you reference to all the relevant case law of the European Court of Justice, but I do expect that all the participants of the conference will get the slides of my presentation. So ECJ has said that when it comes to special procedural guarantees, including those which are applied for interviewing a person, has to be ensured at an administrative stage as well as during the procedure of analyzing the asylum application. So thank you very much for your attention. Thank you very much, Vladimiras. Hopefully you still have managed to cover the most of your topic as you intended. And let us expect that after yet another presentation, we will have more than enough time for a discussion and to cover the aspects that you didn't manage to cover. So, whether the special guarantee mutatis mutandis measures have to be ensured for vulnerable asylum seekers, and 74% of our audience said yes, that such special procedural guarantees have to be ensured for vulnerable people. So now let's have a very short break and we will welcome the new speaker shortly. Oh, that was such a very short break. And I believe that all of you are sitting cozily in your homes or in your workplaces. Now moving on to Romania. She's a prosecutor and she's also a lecturer at the Faculty of Law, and her field of interest is how to communicate with victims, with witnesses, how to cope with stress, and how to help victims and witnesses to cope with stress. She is a volunteer in domestic violence issues. So, Madam Irina,
do you hear us?
Yes, good morning. I was listening to the translation, which is a bit later than your presentation. That is why I did not answer. Good morning. It is such an honor to be here with you. Thank you so much for the invitation. I will speak to you today about communication with victims of gender-based violence. And because I think it is very important to put ourselves in the mood of the discussion, I would kindly ask the participants to join me in a little exercise. It will only take a minute, I promise, and it only requires a piece of paper and a pencil, or even your phone, just something to write down. And I would really like to take a minute and think of a moment when you felt deeply humiliated. It can be something from when you were a child, maybe a professor or a colleague, maybe from nowadays at work, friends. Please take a moment and think of when you were deeply humiliated, and please write down with that piece of on the piece of paper with the pencil one keyword, 2-3 keywords that are related in your mind with that moment. I will do the exercise with you too. I hope that was enough time. I wanted to start with this exercise because humiliation is a feeling that actually triggers in our mind the same centers in our brain, the same centers as pain, physical pain. There was a study at the University of Amsterdam at the psychology faculty, And the trial discovered that whenever we feel humiliated, the brain centers related to pain in our brain, they start clicking, and the wounds left by humiliation are as deeper as physical pain. So we have to start whatever case of gender-based violence we have with that feeling in our mind that the person in front of us, the victim, has been through a deep humiliation. And the pain that she or he went through was actually physical pain. So the first thing, and probably the last one I will let you know, is that whenever you handle this kind of cases, you have to have empathy. And I love the fact that the previous speaker, Mr. Vladimiras, spoke about empathy, because this is something that is never to be left behind. And taking that into consideration, I will now tell you the definition of gender-based violence according to the European Commission. And it is violence directed against a person because of that person's gender, or violence that affects person of a particular gender in a disproportionate mode. According to the European Commission, gender-based violence mostly affects women and girls. It is a consequence of history. It is something that we have to realize it exists. We cannot hide it. And it exists worldwide, even in very civilized countries and well-developed countries. After taking you through this exercise, if I were now to kindly ask you to look again at the piece of paper, do you get the feeling that you had during that time again? Do you feel again humiliated, frustrated, powerless? I do. When I look at the piece of paper and at the words I wrote down, I feel again the same feeling. And this is the second thing that I would like to stick with you, and that is re-victimization. Whenever we hear a victim, we make that victim go through whatever happened to her or him once again. Each time they write down, each time they tell the story, they relive that moment. Revictimization is something that we have to minimize as much as possible. If it's possible, you should conduct a hearing of a victim, especially a victim of gender-based violence, only once. As general procedures, and this is the first step of my presentation, and then we will go to a more specific gender-based violence cases. As general rule, whenever you have victims of gender-based violence, please take into account that they should not go through the same feeling more than once. It is the minimum that we can do for them. And the second aspect is taking into account who is the most suitable person to conduct the hearing. Think, should it be a woman? Should it be a police officer? Should it maybe be a psychologist? When we face victims' children, should the parent be there or not? It depends on the legislation. However, it is deeply, deeply important for the case to know if it is suitable or not for the parent to be present. So empathy, not re-victimization, and please think who would be best to conduct the hearing. You are judges, you are prosecutors, you have the possibility to choose whom to be the person who will be there and conduct the hearing. And now I will go to the second part of my presentation, and that is going to specific gender-based violence cases and tell you a bit more technical aspects on them and some examples of good practices, I hope, or not so good practices, but from which we can learn. And I will tackle 3 areas, and that is domestic violence, sex-based harassment, and online violence, because I think it's a trending criminal phenomena. Domestic violence. According to the European Commission, domestic violence includes all acts of physical, sexual, psychological, and economic violence that occur within the family, domestic unit, or between intimate partners. You have to take into account that it can also include spouses or former spouses, even if they do not live together. 22% of all women who have had a partner have experienced either physical, sexual violence from a partner beginning with the age of 15 years old. When we communicate with victims of domestic violence, the first thing we have to take into account, besides the 3 general things that we have already discussed, is the educational background of the victim. We have to be very, very careful that the victim understands what we are saying and is able to take well-thought decision when we discuss with the victim. And why I say that she has to take a decision, because I'm sure that in Lithuania is the same. The second aspect is that we have to make sure that we communicate with the victim all the possibilities that she or he has concerning how to put distance between the victim and the perpetrator. And if there are children, what are the children's rights? That is why if you do not know yet, please make sure you know at least 1 or 2 NGOs that take care of victims of domestic violence. Please make sure that you know the fosters that are around the victim's place, that the state ensures, and where you can take the victim with the children or not. In Romania, we have the possibility to take the perpetrator outside the house, even if it's his house, because the family, the victim and the children are more important. However, I have to now tell you a story, because I promised I will tell you a little story at each of the 3 aspects I will approach. During the pandemics, in the beginning, in March, there was a huge wave of people coming from outside Romania, in Romania, people who were working in Italy, in Spain, in France, and there were thousands of people coming back in the country. The situation was very stressful for everybody, and we had a huge increase in domestic violence. It was 30% cases increase. And we had the situation when the husband came back in the country, he started being aggressive with the wife, but because it was pandemics and we were supposed to stay in the house and it was a state of emergency, the police didn't know how to take the husband outside the house because he could not be on the street. And to put the victim under in an NGO or in a establishment of the state was also unfair, because it was the victim's house. And in that weird situation, we found a short-term solution, and the victim moved at her mother's house for a few weeks while the perpetrator could find a place where to live, because the state of the emergency did not allow people to walk around the street unless they had a good reason. So solutions can be found, not always the ones seen in the law. That is why, not the first that are in the law. So we have to always make efforts to think outside the box. And the third aspect that I would like you to take into consideration when talking with victims of domestic violence is the economic dependence that they have on the perpetrator. It is usual that the man works and brings the money and in the house, and the wife stays home with the children and has no economic revenues. That is why I'm going back to knowing the NGOs that can provide for professional guidance for the victim to become economic independent. Sex-based harassment, according to the European Commission definition, it includes sexual acts, attempts to obtain a sexual act, acts to traffic, or acts otherwise directed against a person's sexuality without the person's consent. It's estimated that almost 5% of women in EU have been raped since the age of 15. I have split this communication with victims of sexual harassment into two groups, sexual abuse at work and sexual abuse that is not related to work. When having a case with sexual abuse at work, it is also three aspects that we have to take into account. And the first one is that it is almost for sure that the victim feels ashamed of her colleagues. And the victim will not want for the colleagues to find out about the situation. However, the vast totality of the cases imply that the perpetrator has several victims. Whenever you have a sexual harasser at work, this is the second aspect that you have to take into account. It is most likely that the victim that comes before you is not the only one. Usually people who harass at work do this in a frequent way and have several victims. Taking into account that the victim does not want to be exposed to her colleagues and the fact that the perpetrator usually has more than one victim, we get to the third point, and that is the importance of being discreet. And that is why we have to use very special methods of investigation. We have to use maybe phone tapping. We have to use bugging the workplace. And even if the victim is okay with that, we can put a camera on the victim and see how things are conducted. Usually the victims of sexual harassment at work are very brave because they have the courage to come before you as people of the law and expect you to do something and will probably cooperate. And that is why you have to trust them and you have to give them all the means so that you can prove and bring before the court of justice the perpetrator. Sexual abuse outside work, and that is sexual abuse in general, it has several aspects that should be taken into account. I usually recommend, and I've seen it in books, that it is best to have same-sex investigator. A woman who has been through sexual abuse, it is more willing to talk to a woman than to talk to a man. She is very hurt. As I told you, the feeling of humiliation, I told you in the beginning, and the feeling of shame will make her reluctant to speak of her trauma. That is why it is highly important to have a psychologist present. I don't know exactly the legislation in Lithuania, unfortunately, but in Romania, we have this possibility, and I am pretty sure that you have it in Lithuania too, and you can bring a psychologist to help you with the hearing. You also have to be very careful if you take the victim to be medically examined. I've had a very bad experience with a not so professional doctor, a legal medicine doctor, who did not treat the victim right. So you have to be very careful whenever you take the victim through an examination. And now I will give you an example of a good practice that we have in Romania, and I'm very proud that this started. It involves a 9-year-old girl, victim of sexual abuse. It was her father's boss that sexually abused her. The father worked in a construction field. He was a constructor, and the daughter lived with him on the field because the mother had passed away. And during the day when the father was on the field, the boss came and sexually abused the child, the little girl. The father realized it was something very bizarre, and he got the daughter to say a little, not everything, about what was happening to her. They both came before the police, and also the police wasn't able to do much. But we have the obligation that whenever we have the legal obligation that whenever we hear a minor, we have to have a psychologist and the representative of the state from the child care authority. And it was a woman, the lady who came from the child care. And she was very present and nice. And she told the police officers that it is most likely that the little girl was abused, but she could not talk before such a huge amount of people. It was the police officer, it was her father, it was the psychologist, it was the women from the child care. And so the idea came that we should hear the child, and we have the possibility to preserve the hearings before the actual court starts, and we can use that a piece of evidence throughout the procedure. And that is very, very good to not re-victimize the person who is the victim of the crime. So what we did was that we took the little girl into the office of a psychologist, a very good specialist, and we put year heads to the psychologist. And in the court of justice, there was the judge, was the prosecutor, and the representatives of the perpetrator, the lawyer. And they could ask questions. The judge had also earphones. And on a screen in the court of justice, you could see the little girl in the room with the psychologist live. And the judge would take the questions either from the prosecutor or from the lawyer of the perpetrator, ask the psychologist, and the psychologist would ask the question in a manner understandable for the child. The child used drawings. They used toys to show how she was touched. It was different means used by a professional, and the child did not have to be put through a very hard time and not be put through the pain and the humiliation once more, but she could be there feeling safe, and the evidence was legally obtained and used until the end of the trial. And the perpetrator was, of course, condemned. And going back through, I'm going to talk about the third aspect of gender-based violence, and that is online violence. The online is nowadays more present. Well, look at us, we are now online. And of course, the criminals are always before the law enforcement. What is online violence? Online violence is an umbrella term used to describe all sorts of illegal or harmful behaviors against women in the online. They can be linked with experience in the offline, in real life. So you harass a woman on the street or at the workplace and you continue it in the online, or it can be limited only to the online environment. It can be threats, it can be sexual intended words, it can be offensive emails, sharing private images. It is also case of online violence as gender-based violence. 1 in 10 women in the EU has experienced cyber harassment since the age of 15, according to the European Commission. So 10%. Because this is such a vast domain, I will only let you with 2 ideas about this. You have the first is that you have to take into account the type of crime. It is either abuse or it is linked to another type of harassment. You have to be very aware of the type of crime and adapt. And the second one, it is very important to have at least 1 person in the team who understands the technical means. It is very spread in Romania. You have the lover boy method where people pick up girls in the online pretending that they love them and then they oblige them to prostitution. It is very well spread, this online type of crimes. I think my time is up. I think I've finished my 30 minutes. Please remember, first thing, empathy. The second thing, please choose wisely who carries the hearings. And the third one, always look at the economic, education, and cultural background of the victim. Thank you very much.
Thank you so much, Irina. Thank you for your very good presentation, good examples, and we will go now to the panel discussion and to look to these things in more maybe practical manner. And now I will invite speakers for our foreign guests. I will say that if you want to be involved in the discussion and you will want to react, raise your hand physically or virtually, and I will see if you want somehow to be involved in this discussion, because the moderation will be in Lithuanian. It's okay? You have translation. Wonderful. Thank you. Taigi, dabar judėsim link labiau tokios diskusinės mūsų diskusijos dalies.
Launching our discussion is the discussion part, and I'm ardently calling my audience and participants to join the discussion. So after this extremely short break, I'll once again introduce the participants of our discussion.
Grįžtame į studiją.
So back to our office and
diskusinės renginio dalies, kurioje dalyvaus Sigita Rudėnaitė.
Discussion part. So all the speakers, the first part of our conference will be participating in the discussion. What was said, I extremely enjoyed listening to those practical examples, and I would urge the participants again focus on practical aspects of those circumstances and challenges that we face, and especially it's valuable hearing from people who face those situations in their life, and of whether it's necessary to refer to some legal decisions or whether it's necessary just to speak about their experience from interviews and courts. From whatever items that were mentioned, or maybe some of them were not mentioned, what were there situations or things that could be most efficiently transposed to our system or our culture? Which of the items seem to you most easily realizable? First of all, I would like to thank all the speakers. I feel it emotionally charged and enriched in a way of my knowledge, and I would like to start with what was said by Kristina. Speaking, what we can do today is to invite judges, prosecutors, and lawyers, just to invite them to speak, invite them to listen to those who communicate with victims. I've been listening to Kristina on many occasions, and I don't know what makes her so valuable, but she always mentions certain things that are so important: is empathy and humane approach, and especially to the judges. So maybe we made a little mistake that we did not invite prosecutors or advocates here, because when we speak about some perpetrator that behaves aggressively or provoking, being while in the courtroom, it is not the job of a judge to tame such perpetrators. I believe that it is the advocates that take this primary duty to adjust the behavior of their clients and the prosecutors. What is the reality that we cannot escape is that despite the fact that I'm saying this, I still understand that the person who is in court will always take some very negative impression from the court. Whether he is attacked in the corridor, whether he is humiliated in the courtroom, he will always feel damaged and hurt by the court. So what we can do in the court, maybe organize the process without significant financial expenses, because that is our reality. We don't have the premises that we would like to have, and or facilities, but still knowing that we're going to hear some very sensitive court, maybe a very good example, good advice would be to keep the participants away from the court just to the very beginning of the court hearing. Also, every judge that can organize this kind of hearing could manage that process in a way to prevent people from feeling humiliated or attacked, which was very rightly mentioned in one of the presentations. So finally, what we have here is a trust and confidence in our judicial system. Is what do people feel when they leave the courtroom? When my colleague While Kristina was speaking, I easily imagined a situation where there is a victim and a perpetrator, a person who committed a crime, who is aggressive and dangerous, and we immediately start thinking that he is guilty. And maybe we did not mention it today, but still, I believe that speaking about vulnerable group, we could also start mentioning the people who are come to court as victims, as suspects, because among those criminals there can be people with disabilities or minors. Maybe they also need some support and maybe some empathy too. So maybe that is the area that we haven't been speaking much. And a person who is considered guilty because of actual guilt of somebody else, so such person also needs defense and empathy. And when Aurimas was mentioning what can we practically do, I really noted an idea that was mentioned, is not to use any signs of the government or signs of the statehood sign in the courtroom, because where we hear some criminal cases or maybe cases of family cases and asylum seekers, we have been mentioning more than once that such symbols, some symbols, they kind of designate the judges to the upper category. So maybe we should think that it is not really necessary to do in all cases. Maybe the judges don't have to go to an upper level when their desk is a little bit higher than the sitting places of the rest participant of the hearing, because that kind of symbolizes this symbol of power. Maybe that is not necessary in all cases, and this is something to think about in the future. So the first thing would be that as many people as people who take decisions are well educated and well informed and feel their dangerous areas just to avoid mistakes. About 10 years ago, I suggested in one of the conferences that we were speaking about the courts, I suggested that maybe the judges don't have to use those gowns and just sit a little bit higher than the other participants. But I was not really understood clearly, because this symbolizes some kind of distance between the judge and other participants. But it's important to see that that distance is as short as possible, because in a way it causes fear. What do people feel when they come to a courthouse? That is not a very usual place for them. Court is still associated with some kind of repression, institution, authority that can change your life. So
elementarus dalykas, pasitikim savanoris, teismo darbuotojas,
Maybe a person entering the courtroom could be met by some volunteers, maybe a couple of sentences about the weather or breakfast or whatever would create some relaxing atmosphere, and people would become more open, would get rid of the fear. But what else courts can do just to make their image a little bit more friendly to the participants of the hearing, so that people don't feel so suppressed. So sympathy, empathy, such concepts are very important in those situations. Thank you of your observations, and thank you to the observation by the chairman. So I can think about quite a number of different ideas. When I participate in court hearings for years and years, where I often try to help the victim by just holding the hand. On the other hand, I fully understand the busy life of the judges, but nevertheless, we speak about the victims. We think about what victims think, Maybe they sometimes see some kind of uncontrolled behavior of the others. It's just smiling perpetrators, shouting and making jokes around, and maybe the secretary also does that. But still, looking at those positive examples, it's not really necessary, not necessarily on the part of the judges to impose some serious sanctions, but just to control the situation, to put people in their places. So then we think, what kind of science is that? Is that some kind of new psychology knowledge? But I think the most important thing is just to ability to see things and to pay attention and be able to control, just not to create the situation where victim would feel like everything is against him. So other thing is that we do organize, let's say, transportation of victims to the courthouse. We provide that support and communication outside courtrooms too, and we try to smile, and there is some positive communication and speaking to the victims, and that is fantastic. That eliminates that anxiety, that fear, and that is very important. But nevertheless, I would like to ask the judges. Of course, I understand nobody's going to rebuild or rearrange those courtrooms, but I would just ask the judges to exercise all their abilities to prevent those direct impact, so that we don't have to hide in toilet rooms or in corridors. Maybe there are not so many measures to avoid that, but just to avoid the traumatic experiences. So I would like to just to see this kind of arrangements as a priority.
Kartais į mobilų telefoną gaunam žinutę,
something like when you go to a store, to some institution, and then you receive a message to your iPhone trying to rate in stars how many stars you can assign to this shop. Let's say like maybe one would receive 3 stars, the other would receive 5 stars. So maybe maybe a court that could be proud of being elected as the most friendly court. Friendly court could be benefit at all. It's a very good idea to listen to the opinion of the victims, but yes, that's a very important thing, just to ask opinion from the person speaking victim. A question from the audience. You mentioned some cases, hearings that
asmenų apklausose neturėtų dalyvauti ir psichologas, kaip suprantu, baudžiamosiose bylose, kurios liečia pabėgėlius. Mes turim šiandien
psychologist, whether or not a psychologist should be present in court hearing, examining the cases related to asylum seekers. So don't you think that a psychologist would benefit the situation a lot? Yeah, of course, that would be a good idea, but I was speaking about the administrative cases. When a person files an application and the migration department takes a negative decision, the person has the right to appeal, and such appeals are heard in Vilnius local, Vilnius regional court and Vilnius Supreme Court, Supreme Administrative Court. So that is according to the administrative proceedings. Yes, that was my idea a long time ago. And according to the law and order of the Minister of the Interior, in the administrative stage, when a migration department examines the case, the participation of the psychologist is necessary. A psychologist is allowed to participate in such interview, and that was exactly my question, that maybe this guarantee could also be provided when hearing the appeals in courts, because this judicial stage is the second stage in the asylum procedure, but it's still the asylum procedure. And as I said, it's the situation where people might have to speak about very painful experiences. And as my colleague from Romania mentioned, there is a huge risk that the person can be subject to the secondary victimization. I'm from the media, and we hear a lot of such things also from the judicial area and from our life. Such details really do not add a lot of confidence to such cases. It kind of deters the people from giving such details in further in subsequent situations, because such details and like in the rape cases can hardly be very useful, because it's important that people feel protected from publicity. They feel that whatever they said in the courtroom stays in the courtroom. Yes, of course, it's very important. With all my respect to the media, such cases, asylum cases, are confidential. And there have been cases several cases when the details from the asylum case were published and they were discussed in the media, and that is not a proper case because one of the guarantees, one of the obligations on the part of the state to ensure this confidentiality. The asylum seeker is obliged to provide such details, and the state is commits itself to ensuring full confidentiality. Nobody will ever know those details, neither other persons, neither some perpetrator in the country of origin. That's why there is a very limited number of circle of people that are allowed to participate in the court hearing, and that is absolutely evident. Asylum cases, violence cases, rape cases. Do you think that all those cases should be made strictly confidential and with a strict requirement not to discuss publicly? The confidential cases are regulated on the level of the legislation. This is not really necessary for the judges to stress that separately. The question is how that information is leaked from their courtroom. So maybe you as a journalist know, but all sensitive aspects of human life are protected in courtroom. We've been reprimanded that the court does not disclose sufficiently. Yes, we are close, but not because we protect our judges, but we protect the privacy of the people who come to the courtroom to participate in the case, and they have all the rights to their privacy. So such order by a judge is not really necessary because it is provided in the law, and any comment from the court would be neither necessary nor sufficient. We know that happens. It should not happen, but still it happens. So I would like to ask our guests
vis dėlto, ką jūs patartumėt? Daug dalykų akcentavot, ką reikėtų, kaip turėtų būti, kaip Europos teisės aktai reglamentuoja pažeidžiamų grupių apsaugą. Vis dėlto, kokie praktiniai žingsniai
what is the good practice in the European case law? What are the steps taken in courts to make the courts more friendly to the participants of the hearings? And the question is to Madame Urumova. Yeah. What measures could be taken on the European level just to make the courts more?
Did you understand? Did you catch the question?
To make the courts more friendly to the participants of the hearing.
Thank you, sir. Well, the approaches can
Ačiū
be
labai,
manifold.
gali būti,
As I already mentioned, no, I understand the question perfectly. Yes. Yes. As I said in the beginning, the approaches can be manifold, and in general, we have to look at the specific kind of need we aim to meet, and at what kind of arrangements are needed to meet it, because in some cases the measures can be as simple as court planning. For example, when it comes to people with disabilities, including both people with mobility restrictions and people who have different sensory disabilities, court design can help a lot. And it's not necessary to build new courthouses. In some cases, even adjustments to the existing design can help a lot. There have been, for example, very successful practices of using beacons, electronic beacons, to help people with sensory disabilities navigate the court premises. Of course, it is not cheap, but technology is our friend here. There are also solutions that help address the needs of more multidisciplinary nature. I think I mentioned the Barnahus concept. It's not, of course, it's not limited to courts. It's mostly focused on the pretrial stage. But Barnahus is a great approach in this case because it can be used, for example, to take the child's deposition. If it is assessed that the child would be unduly endangered, traumatized by appearing in court, one option is remote testimony, but a deposition is also possible. Well, it depends on the legislation of the state in question, of course, but Barnahus environment is an ideal environment to take the deposition from the child and not burden him or her with appearing at trial and facing the perpetrator, the alleged perpetrator, which would cause unnecessary pain and suffering to the child, especially in cases, for example, of sexual abuse. This is used very widely. And another option that I was thinking about is, of course, it's the remote testimony for the child, which is also used very widely. And in this case, you look at the possibility of seeing seeing it only one way, ensuring that the child does not observe what is happening in the courtroom. This way, the child can be better isolated from that environment. When it comes to, well, there are also other groups of people with specific needs. These are the most salient. I would like to also mention victims of sexual and gender-based violence. But in this case, the problem is not so much with creating a specific setup or creating a certain add-on, like in the case of children, but mostly with ensuring that the person receives uninterrupted help, uninterrupted support from the beginning through the end. So again, we cannot tackle this without having a comprehensive end-to-end support service in place. But when it comes to court-level solutions, I could also mention the separation of circulation pathways so that the victim and the alleged perpetrator don't coincide, and having maybe separate waiting areas even for such traumatized victims, where they would also have access to various devices to alert the court security service if need be, like alarm buttons. That's probably the gist of it. But if you have more specific questions about a specific group, I would be happy to answer them.
Thank you, Irina. Thank you. Irina, what's your ideas? Speaking about practical ideas, how to make courts more friendly to vulnerable people.
We have in Romania a special room that is designed in some courts only for hearing children. It is a room that's friendly, it has some toys, and the judge goes in there without the gown, without looking very imposing, and just talks to the child. It is an official talk because afterwards the judge writes down whatever they spoke with the child, and it is also recorded so that it won't have any discussions on the validity. It is also usual that we have this kind of rooms in the prosecutor's office or at the police station. Not many police stations have them, however, but at the prosecutor's office we have this kind of rooms, especially designed for children. I loved Mrs. Irina Urumova's ideas. We have some of them implemented. We can hear witnesses or victims through video conference, and if necessary, even blurring their face and their voice. That is also in order not to re-victimize the person. So to add on what Mrs. Urumova said, I would say that not only having different rooms, but we can even use technology to hear everything through a video conference, and the parts can ask questions. You have the prosecutor, you have the lawyer of the defendant, you can ask questions. And also, I don't know what's the procedure exactly in the court, but I would actually recommend to have the victim and the perpetrator heard in different days. So you have one day when the victim is in court, and a totally different day when the perpetrator is in court, and the hearing of the victim can be held by the lawyer. They do not have to meet. So you can arrange only by schedule the hearing in such a manner so that the victim doesn't have to go through this again and again. And a big idea to stick with us is to hear the victim as few times as possible. Maybe once, maybe maximum twice if really, really needed. But don't put the victim through what it's been through too many times because it is painful.
Thank you. Ačiū labai, dėkui už puikius patarimus ir idėjas. Na, jeigu norit reaguoti, drąsiai kelkit ranką mūsų lietuviškos panelio dalyvių.
If you have anything to add, please, you are very much welcome. But there are some questions from our audience. Simona, interested in asylum matters. The question is, modification, how efficient could be modification, hearing the cases of appeals, and what measures are necessary specifically at this time when hearing the cases of asylum? Those are very serious questions. Answering my first question, I would say that although we have been speaking about this today, what is the main challenge? That is when we speak about vulnerable asylum seekers, so anybody else that we were speaking today. But my colleague Kristina was mentioning certain challenges. They are very similar to those that we see in asylum proceedings. What is the main challenge? The challenge that when you speak to a person who has undergone tortures or sexual violence, what is the main challenge? First of all, the people who were perpetrating maybe representatives of some repression organizations. They might look very similar to those officers that conduct hearing in Lithuania. So when a person sees an officer, he may experience flashback. So he feels like he is re-experiencing the same challenge. The second thing is that all the psychologists mentioned and experts in interviews is that one of the main challenges is the disproportionate allocation of power. When a person was tortured or raped, he could not control his body, he had lost all control, he could not control his freedom because he was directly dependent on actions of other persons. So it is extremely important when speaking with a person is to help him understand that he has control of his fate, of his body. That's why we speak here about this horizontal relation, very important horizontal relation. Maybe I could illustrate by an example. Because I speak only about asylum only, because I am an expert in asylum matters only. So our appeals are heard at administrative courts. Administrative courts examine different other cases. Asylum area is very specific. In some other cases, some other countries, there might be quasi-judicial institutions or some separate organizations that are kind of qualified in examining asylum cases. My colleague that had been working for many years in Denmark as an asylum judge mentioned that in Denmark that the Danish Asylum Board has a standard. If a case is related to rape or torture, it is extremely important requirement that there are no signs of power in the courtroom. Everybody sits at one round table. Everybody understands understands the relations, but this environment and the atmosphere and the room needs to be very facilitating. And I could suggest some serious reforms in this system. Maybe this conference could be a first step in that. Somebody said that I participated in creating legislation, in asylum legislation, in European Union. I need to admit, because when I was participating in drafting those directives, I was not thinking about courts. I was thinking about administrative institutions. Because today I understand that there are many things that have to be ensured in administrative stage and actually very relevant in courts too. In Lithuania, there was one case which highlighted one situation. There is a standard that if a person requests that the interviewer And the translator, the interpreter, has to be of the same gender as the applicant, woman or man. So my question is, if an applicant asks for this guarantees in this kind of guarantee in the appeal stage, let's say he would say, I want all judges to be females and interpreters to be females. The answer is no. There is a rule that the person does not have this kind of right to make this kind of request. So maybe that's just a good idea that organizing the reform would be an important thing to take care of. Yeah, so many important things, and we'll be speaking about the symbols and some other matters that are important in sexual abuse cases. I understand that there are laws, there are court decisions, but maybe we could appeal to courts with some kind of request or recommendation in cases of asylum rapes or asylum rape or abuses of children. If somebody asks that I want to see all the judges of the same gender, I understand that the law does not provide for this possibility.
So to respond to this question is, once we start improvements in one end, then we make the situation worse on the other end. And recently there was quite a resonant issues, which was some corruption of judges, and that is that the distribution of cases shall be done automatically by a computer. We have so many rules that to include yet another one to request the same sex or same gender judges or prosecutors, I believe it is beyond our possibilities, because we're now in the midst of so much fire that our national system provides priorities to accidental distribution of cases. So whether you're going to get, so it's basically the luck of the draw, whatever a prosecutor or whatever the judge you may get, you got by the computer automated process. And what do you personally think about robotization? Well, I always have this approach. When you go to the extremes, then you make something worse, because there are some traditions. And the courts in countries which have a good trust in judiciary, they trust in whatever methods are being used by the courts. I've been working in this field for the past 30 years, so I do expect people, the public, to trust in me. So if we were sending this message that, first of all, you have to trust the judge, because fairness or justice shall be the core value in our society. So if this principle or this opinion would be the prevailing one, you may well imagine that there may be a highly skilled or professional judge, or the one who is compiling the panels of judges could also look into the interest of a certain case, or perhaps a specific judge is much better placed due to lack or not lack of empathy. We can have another situation where we are dealing with business-to-business cases. Of course, naturally, I would pick and choose a judge who shows much more empathy to deal with sexual harassment or refugee or migrants cases. But unfortunately, we live in the times where we do not have such a freedom of choosing the judges or the prosecutors for the case. So perhaps some modifications are necessary to our legal acts, but referring to your idea of building trust, public trust in the judiciary, and I believe this is a two-way lane, and if people indeed had this reason to trust in the system of the judiciary, then any questions about empathy, lack of empathy would be already a secondary. And unfortunately, the time is really fast, so the last intervention. I think then that then any wish for specialization would then be lost in our case. So do I understand correctly that specialization is not necessary? You're wrong, by the way. But it is only possible when we have a certain number of judges who specialize in a certain type of cases. If there is only one single judge who is specializing in court, then no specialization is possible, because we know in advance which judge is going to handle the case. So specialization is necessary, but it doesn't mean that sometimes we are in the position to pick and choose a woman judge to deal with some sensitive or vulnerable issues. It could be just as well men who fall victims to sexual abuse. So specialization is possible. Sigita Rudėnaitė, Irina Urumova. Thank you very much to Kristina Mišinienė, Vladimir Senyovas, and Irina Korsei Vulturianu. Thank you very much for having been part of our discussion. And I see that we're already encroaching upon the lunch break. So we already started talking about practicalities of all the important aspects. So we do expect to continue our discussion after the lunch. I think that it is always important to talk, be it the distribution of cases or any other moments. The core here, or the underlying principle, is to remain humans in all these processes. And this is what, indeed, it takes quite so little just to raise your hand for a judge, to simply to calm down this theatrical performance of maybe misbehaving suspects. Sometimes it takes only a couple of sentences to make the situation much more bearable for victims. Thank you very much for all your inputs, and let us don't forget one of our basic needs. One is to have lunch, another is to have some exercise. So let us use this opportunity for grabbing our lunches and for doing some short exercise, and we will come back at 1 o'clock. And we will talk about practical implications in implementing better protection for vulnerable members of the society. So in less than 1 hour, we shall meet again. So everybody, please have a nice lunch.
papildyt galėsit kažką, tai viskas labai super.
Jau vėl apie 100
Kągi mes grįžtam į mūsų darbo gretas,
So we're back
nuotolinio
to
darbo
our
gretas,
conference, our
konferencijos
remote
gretas, tikiuosi
conferencing.
skaniai papietavo,
I do
šiek
expect
tiek
that all of us
pajudėjo.
had
Na, turim privilegiją, tikrai
pleasant
atrodo
lunches,
daug
that had some
dalykų
possibilities for
mūsų
exercising.
pandemija atėmė.
There are some
Bet
things
vieno
that the
neatėmė.
pandemic
Vis tiek galim bendraut ir pakankamai
took from
sėkmingai. Aš
us,
prisimenu
and
savo
luckily we still
vaikystę
can
ir
communicate,
savo vasaras
although
kaime,
remotely,
kuriame buvo
but
tik
still.
vienas
I remember
telefonas,
my
kuriuo
childhood,
galėdavau
back in my childhood in
paskambinti
the
vieną
village
kartą
that
per
I was
savaitę į
living in.
namus.
There was
Tai mes dabar turim galimybę
the
štai
only one,
Norvegiją,
the only
Rumuniją,
telephone, fixed line telephone that I
Armeniją
could use
prieš
once per week to
diskutuojant.
call
Tai
home.
ačiū už šitas
So
galimybes,
thank you very
kurias mums
much,
suteikia
all the participants,
mūsų
and
transliacija
luckily
ir
we have all the
visagalis
technological
internetas.
possibilities
O dabar
and the
grįžkime prie
almighty
mūsų
internet,
temų,
which
aptariamų
makes this
pažeidžiamos
conference
visuomenės
happening.
grupės teismuose, kaip
And now moving
atpažinti
on to the third
ir
part of our
atliepti
conference,
poreikius. Ir aš
titled
norėčiau
Challenges in
pakviesti
Court
labiau į tokią
Proceedings.
praktinę
I would like
mūsų
to invite
diskusijos
you
dalį, nors
to
tos
start
praktikos
a
čia
more
netrūko ir
practical
pirmoje dalyje. Kalbėsime
part
apie
of our
iššūkius teismų
conference.
praktikoj ir labai
So we're
malonu,
going
kad
to
turėsim
cover the
teisėjus,
challenges in
teisėjus
case
praktikus,
law.
kurie galės
Luckily, we're going
pasidalinti
to
savo
hear from
mintimis, kaipgi
legal
galima būtų
professionals, meaning
tas
judges, who
inovacijas,
will speak
kurios darytų
from their
teismus
first-hand
draugiškesnius
experience
pažeidžiamom
of
grupėm,
challenges in dealing with
įkultūrinti,
vulnerable
paversti
groups
realybę,
and how
paversti
to
mūsų
make those best
realybę
practices
teismuose mūsų
a
gyvenimo
reality
dalimi. Tai man labai
and
malonu
part of our
pristatyti
judicial life.
pirmiausiai
So I'm
Vilniaus
very
miesto
much
apylinkės
happy
teismo
to
teisėją
give the
Viktoriją
floor to
Šelmienę,
Victoria
kuri
Šelmienė,
papasakos
judge
apie
at the
bendravimo
Vilnius
su
City
pažeidžiamomis
District
grupėmis
Court.
iššūkius
And the topic of her
pandemijos
presentation
akivaizdoje.
is
Viktorija,
challenges
matau
of
jus
communication
puikiai,
with
tikiuosi,
vulnerable groups in the
netrukus
face of a
galėsim jus
pandemic.
pamatyti ir jūsų pranešimą
So
taip pat
I already
išgirsti.
see Victoria's
Prašau.
face on the screen.
Mikrofonas.
Hello to everybody. Thank you for being back. While I was listening to the first part of the conference, I was thinking about how we as the judges, as legal professionals, could make it this experience, court experience for the vulnerable people, less harmful as possible, because that would be one step forward for reintegrating them into the normal way of life. So what shall we do on our part in order to make this journey back to the normal life possible? And we can start and talk about the pandemic. And by the way, the beginning of 2020 has come as a shock to most of us. Because our lives have changed, and the court reality has also changed. Today, I would like to talk about the changes that were triggered by the COVID-19 pandemic and how do we cope with this new reality, how we're making this less stressful for people, litigants, and how we're making it less stressful for the judges so that we could administer justice. So now I would like to share my slides with you. Yes, here they are. So today the topic of my talk is challenges, and COVID-19 pandemic is the major challenge that we in courts are facing. For almost a year, the whole of the world, ever since the end of November or beginning of December 2019, we've been living in this COVID-19 crisis. So there are a number of challenges that all the people have to face with, being the police officers, being doctors or judges. How shall we arrange our activities in order to perform all the necessary functions, how to host the hearings, how to communicate with the litigants or parties to the proceedings? So in the beginning we had so many questions, how that we were at a loss, most of us, as human beings, as citizens, as judges, or prosecutors. Luckily, human beings are quite creative creatures, and after initial shock, we managed to find solutions, including solutions for work at courts. Before the 16th of March 2020, the courts in Lithuania was not yet feeling any effects of the COVID-19 situation in the world. And as of the 16th of March, the situation has changed with the introduction of the lockdown. From that time on, we were learning the new ways how to proceed, and we were looking for the answers to those multitude questions of how. And gradually, all the hearings were becoming online, and in summer or beginning of autumn, once the lockdown restrictions have been lifted before the second wave, the courts indeed were very hectic due to the fact that after reintroduction of judicial activities, there was a backlog of the cases that the courts had to deal with, and every single judge, by way of performing their functions, they were striving to do their best in order to deal with the cases as fast as possible. So this pace in the beginning of autumn was indeed quite a remarkable one. And the second wave, with the second lockdown, the hearings in courts have not been postponed, but the majority of all the hearings were happening remotely. So the second lockdown has finally introduced a new mode of working, remote working. Personally, I'm a criminal judge, and I personally feel interested in the impact of the COVID-19 pandemic on the situation, on the criminological situation and on the cases. So I already see from my own personal practice that this COVID-19 pandemic had a certain toll on the people. People were locked in small spaces with very limited possibilities of free movement, and already in early spring or specialized support centers were very outspoken in terms of an increasing wave of domestic violence. So I believe that was inevitable, given the situation. And we, as judges of the criminal cases who have to deal with domestic cases also as part of our portfolio, we always notice the direct impact of any extended period of all the families being packed in a smaller environment. And in that particular case, when the whole of Lithuania was locked in their homes, that was only inevitable that the cases of domestic violence have become on an increasing trend. And the number of pre-trial applications on domestic violence in Lithuania in March and November in 2019 and 2020, and I chose these two periods for the sake of comparison. And again, as I mentioned, as of the middle of March 2020, there was the first wave and the first lockdown introduced in Lithuania. And now we're meeting in the middle of December. So what do the statistics show? The number of applications on domestic violence has been increasing, and the blue column is for 2019, the red column is for 2020. And we see that the red color is increasing. I decided to choose two possible measures that are being applied, temporary protection measures that are being applied by courts. And first of all, that would be barring orders or living in separation orders. So whenever we have to deal with domestic violence, a court may introduce such a measure as a temporary protection for victims. So there were indeed many more people would be calling the police, and there were many more pre-trial investigations taking place. These figures are not indeed drastic in some sense, even though the red column has been increasing ever since. We have calculated the number of applications on domestic violence, 55 more in 2020 compared to 2019. So overall, on a national scale, this is not something extraordinary. But still, 55 new reports of domestic violence is quite an important figure. Personally, I was interested in the situation of minors. I was talking with court psychologists who noted a decreasing number of interviews of the minors, simply because in March and April, all the operations and all the activities, courts including, were put on hold. So, on the right-hand side, we see the number of applications to interview a minor as a witness or as a victim. And we see that in the months of June and July, the situation has changed, and we see a growing number of applications for interviewing the minors. So June, July, August, and September, we see that there are some not that many changes were taking place in that sector. Even though in the public space the police was claiming that the number of reports on domestic case violence has been increasing during the periods, during the reporting period, the number of applications or requests to question a minor was smaller in 2020 compared to 2019. So we may ask ourselves the question, why is it the case? And an explanation is a very simple one. Due to the decreased mobility of the people, all the children were sent to distant learning mode, and therefore the field of activities has been reduced, which eventually had a decreasing tendency in crimes. When it comes to crimes committed in public space, they have been also decreasing. I'm particularly interested in any dynamics of cases, criminal cases under Article 140 of the Criminal Code. So there was a growing number of requests to live of barring orders or instructions to live separately from the perpetrators, etc. The number of cases received under Article 140 of the Criminal Code, which covers domestic violence cases, this number was higher in 2019 compared to 2020. So in aggregate figures, in 2019, the number of such cases was 3,792, and in 2020, the number of such cases was 3,603. So a number of increasing reports on domestic violence, and being this number low, it doesn't mean that perhaps the police was summoned to the scene too early or prematurely, or maybe people were reacting or overreacting to some minor instances of domestic violence. Simply, people were electrified by this overall pandemic tensions, and they were overreacting sometimes to petty cases of misunderstandings, and most of the people were irritated or overreacting or oversensitive. A good news about the pandemic is the following. You might think that the lives of the people have been put on hold, people are dying, but on a positive side, I also have to note something. During the same period, there was a smaller number of cases where minors were suspects. And this is a good news, I believe, that there is a decreasing trend of minors as offenders in criminal cases. And if an accused or a suspect is a minor, and the fact that we've been getting far lower number of such pre-trial cases is a good news for us. Of course, we shall not be complacent and think that simply children or the youth stopped misbehaving or doing some wrong acts in general, but maybe this distant learning has also introduced some positive side to the story. Now moving on to the next part of my speech, and what actions can we take in order to make the experience at courts for the vulnerable people less stressful. I would like to say that we are getting new judges who have been recently taken the oath as a judge, and the judiciary has been revived or renewed with new faces. And therefore, I would like to remind the old-time judges and the newcoming judges to remind all of us that we have court psychologists working in courts for a couple of years already, and they've been rather successful, I have to say. And these are professionals of the area, and they are protecting the interests of children and other vulnerable people from stressful experiences at court. A court psychologist initially was introduced as staff supposedly who was meant to help children. Later, we started availing of the services of court psychologists also in interviewing vulnerable members of the society. And psychologists helped us a lot to identify these vulnerable members of the society. So I would like to encourage judges to use this possibility of inviting a psychologist. Because psychologists are experts, they know how to talk to people or how to rephrase questions to make them less stressful, and how to physically help people, for instance, by giving a glass of water when it is most needed. Sometimes it makes a difference to allow a person to open up and say what has happened to him and her. A court psychologist is a very qualified mediator between a litigant and a legal professional. He or she helps to collect all the information relevant and all the child development features or any disorders that may be relevant for the case. And they help to understand why all of a sudden a certain person, when summoned to testify, is silent, or why this person is not telling the truth as we might think, or we might have a wrong idea that a person is lying to us. But unfortunately, this person has been living through a very difficult trauma, and he's still suffering from post-traumatic disorder. And psychologists are very much helpful when it comes to uncovering the truth. which is sometimes hiding beneath the surface. We, as judges, are experts in criminal law, and we sometimes tend to forget that we might need to interview a person who has been a victim to such a crime, and there should be a completely different approach used in their regard. So we have to prepare a party to the proceedings in an appropriate way, because in that case, a person understands the legal proceedings better, what is expected from him or her, and what are the following or the next steps to be taken. So this uncertainty is dispelled if we prepare a party to the proceedings in an appropriate way. Sometimes such minor details as know where to turn to or which corridor to take eases the pressure of coming to testify. So if you know what you come here for, who is going to question you, how many people there are going to be in the courtroom, and sometimes the court psychologist can help a lot. And by putting a witness at ease allows or enables us to expect a valid testimony at court. Because we have to admit that for victims, any presence in a courtroom is yet another stress. If they are put through the same trauma and they are forced to relive or to re-experience this trauma once again by giving evidence. Yesterday, I had a case, a criminal case, under Article 100, well, I don't remember exactly the article. This is an employment case, an accident at work, a person died after that. So there is no criminal element in that case, simply there is a representative of the victim. We are not involving children as victims of that case because this is not a refugee status or it is not a human trafficking. We are dealing with a situation where the breadwinner, the father, died in an accident at work. So the children were interviewed by psychologists, and then we deliberated the case without the presence of the children. So I would like to give you the response that we heard from the witnesses. And one of the witnesses was a contractor, a representative of a contractor, who was summoned to give testimony. And this company was a construction company building a building, and a person died. And the witness had no direct contact with this disease. They were completely two different companies, completely different objects. So we issued a summons, court summons, to this witness. And the attorney of the victims indeed went an extra mile and asked very difficult questions. And I also find it very unpleasant to hear the questions, the way they were formulated. And I therefore responded and I intervened. And you know what the witness told me? I haven't been sleeping. I haven't had a wink ever since a couple of days because I received court summons. And when I was preparing for today's conference, I somehow remembered his words. And I took them to my heart. Yes, indeed, whenever we send a court summons, and for us it's an ordinary daily business, but a person who comes to court for the first time in his or her life, this person is anxious, cannot sleep for a number of nights, and he or she is worrying how the questions are going to be raised, if his or her attorney or the defense attorney is going to abuse his authority and going to bombard him with the questions. So it very much then has we have to think really carefully how we behave in courts. I would like to encourage the judges to use the possibilities of and services of psychologists. And I think that in every single district in the local courts, we have psychologists. If not during the proceedings themselves, we could at least seek prior advice from a psychologist how we should approach the case in the most appropriate way and what would be the best way forward in order to make this experience at court for everybody less stressful. I would like to say a few words about the interview rooms. Our guest from Romania also mentioned interview rooms for children. In Lithuanian courts, there are a number of such rooms already furnished. A couple of years ago, this was only an idea, and now it has come reality in many of the courts. And on the screen, you see one of the interview rooms in one of the local courts of Vilnius, which are meant to be used for interviewing vulnerable parties to the proceedings. And this is the room, which is directly linked with one of the courtrooms, which have all the necessary video conferencing tools, so both the sound and the video, audio and visual connection. And the child is sitting in the small room with a psychologist. There is nobody else, with an addition maybe of interpreter if necessary. And we try to ensure that there are no any other interferences in that room apart from a child and a psychologist or any vulnerable person sitting in that room. Sometimes even the presence of a certain person in the same room, if you know that the perpetrator is right here, right next beside you, sometimes may disencourage you from giving testimony. I would like to address new judges who are only starting the first years of service to use interview rooms as many times as possible, even if you're not interviewing children. These could be victims of sexual abuse or prostitution or domestic violence cases. When you feel that involvement of a certain vulnerable person might be influenced by the court proceedings, so that this vulnerable person would not see any symbols of power in the courtroom. Now we have technical possibilities in courts, maybe not for all the cases, but nevertheless, we shall always bear in mind this as a valid option for interviewing domestic violence victims, children, or victims of prostitution. And you can well imagine if this courtroom was much bigger than it is shown on the screen, then it is indeed very intimidating. Volunteers or court volunteers can help us out to put witnesses at ease. They know how to make it the experience less stressful for the participants. And therefore, I would like to encourage the judicial community to use court volunteers on a periodic basis. Voluntary activities in Lithuania has become quite a fashion in Lithuania, but every fashion has some good things, and especially it is a good one if it has some tangible results. And the court volunteer is a non-professional, non-legal professional, or it could well be, but for most of the time these are law students most often, or elderly people from a third age university seeking postgraduate studies who have a good life experience, or they are willing to share this life experience. So what is the function of a court volunteer? A court volunteer helps to get yourself oriented in the huge court house, finding the right way, the right corridor, or the right utilities if they need to find the room, not to get lost. And the court volunteer also reads the witness, his or her rights as a witness or as a victim, and what are the rights or the duties are still going to be further explained by the judge, who is going to take the oath of the witness. But this knowledge of an oath that you're going to be asked to take sometimes puts a witness or a victim at ease, and they know what to expect at a courtroom. And sometimes a court volunteer is the person who gives you a hand when you need it most. At the time of the pandemic, the activities of court volunteers, of course, was restricted. But by the way, before the pandemic restrictions, they were indeed very helpful in arranging the hearing of the case on the 13th of January, our independence fighters who lost their lives. So there were a number of practical issues that had to be dealt with. There were a lot of media involvement, which had to be arranged and coordinated. So these were court volunteers who helped a lot to get everybody navigated into the right place and the right time. So we're very happy to have responsibility of using the service of a person who wants to be helpful, and in particular in such difficult situation as we are all living in at the moment. Yet another challenge is remote court hearing. Courts all around the world, be it Australia or America or Lithuania, are hearing the cases from a distance. So what does it mean? Is it a temporary necessity, or is it a new reality, a new norm? Maybe we're going to continue working like this after the pandemic. In general, a remote court hearing has been used in the past as well, but not to such a large extent. And the Judicial Council is recommending to use the remote hearing mode in court hearings as much as possible, because this is a way to ensure security and safety of the participants. Now, I would like you to answer these questions. What is your experience in your remote participation in a court hearing, to judges and not to judges? And the second part, so the first part of the question, what is your experience of hearing cases remotely? This is a part of the question for judges, or experience of hearing cases when you were party to a hearing. So you might ask from your personal experience, or you might try to imagine what it would be like. And there are three possible options: more positive, a second option would be more negative, or a third option would be a neutral experience. So why am I asking these questions? These questions are coming from a real situation. First of all, when it comes to the regulation, I will say a few words about that. According to the Civil Procedure Code, there is a very clearly defined wording how remote or teleconferences have to be used. Whereas when it comes to the Criminal Procedure Code, there are a number of articles which define the participation of litigants in remote hearings. Basically, it says of the obligation of the state to ensure the possibilities of holding audio-visual remote hearings in criminal cases. At the moment, we are having such remote hearings in criminal cases. But I would very much like to have this initiative regulated under one single article instead of having them in 7 or so articles. We may ask ourselves a question, should we work under the new normal way, and should we continue working under the new norm? Because now all our lives have been moved online. So why not a remote hearing? When it comes to criminal cases, we sometimes face a very low computer literacy of litigants. Sometimes there are parties in the proceedings which have never seen computer or internet in their lives, and now we are asking them even to zoom into the meeting and be active participants. So this computer illiteracy is not as scarce as you might think. Sometimes defense lawyers are against remote hearings. So I would very much be interested in hearing from my colleagues, how often do you hear such an argument presented by defense lawyers who would be opposing remote hearings? A very complicated arrangement of the process. This is yet another argument used by the opponents of the remote hearing. There are cases in the United States case law where litigants are not behaving. And what shall we do with them? Shall we zoom them out, or shall we disconnect them because they're misbehaving in front of the camera? So there are also a number of other reasons why a remote hearing is not a solution for all. So it is not a one and only solution, but it is still one option that we can use in our practice. A few words about the child, and I see that I'm already abusing my time a little bit, but just a very few words about interviewing children. The pandemic has shown that according to the case law, whenever it comes to interviewing children remotely, that could be quite a successful approach, because when children stay in the environment that they know, they are much more willing to disclose their experiences, and sometimes they even take it as a game. They believe they are participating in a game, telling their story, or sometimes the children are given all the possibilities of giving testimony after classes, so they're not skipping classes, so everything looks fine in that regard. And unfortunately, there is a negative side to remote interviewing children. If a child is less socially capable or has experienced a very huge trauma, it is much easier to make a rapport with him, to make a contact when you are physically present to this child. Whenever a child is given testimony remotely, you are not sure if somebody else is not standing behind him or in front of him or her and showing any signs or approval or disapproval. Because remember what I said in the beginning, it is very important who is standing right next to a child giving testimony, because that may have a significant impact on the disclosure of a child and on the success of the case. And to complete my talk, I have collected a few tips for the future, or advices or recommendations that we could share with our litigants whenever we are sending summons to a remote hearing. So whenever you are willing, you're more than free to do so, and you can use my recommendations to make it a remote hearing less stressful and to run more smoothly, so that first of all, the litigants have to make sure that they know the timing right, they know the link, they've got the link to the Zoom meeting right, they have to check connection speed or availability of internet well in advance, so they have to check the connection properties coming from the courts. These are all the, like I'm speaking elementary things, but still, they are worth to be reminded of. You have to make sure that your computer is connected to a charger, for instance, or there would be disconnect some other devices which are using the internet capacity as well. What else is important to know, and I would suggest advising the person to put an ID card or a passport right next to the computer and all the necessary documents, the case material. And it would be very good to have the contact details for the judge if all of a sudden there is a disconnection of the internet, so that he or she could immediately contact the court and inform the court of any problems experienced, technical problems. Overall, recommendation would be to switch off the microphone, because sometimes they record what you are not willing to be recorded in all your surroundings. People are sometimes willing to speak out, especially when it comes to criminal cases. They want to be heard, and they have the right to be heard. But it is very important to make sure that only one person is speaking at a time. And if we are speaking all together at the same time, we're not going to hear what each of us is telling. So let us wait and let us be polite. Even though speaking in unison by everybody at the same time is quite a usual thing for people, especially if you are deeply involved in the case. You have to dress up yourself accordingly for the occasion, especially make sure that the environment looks decent, especially this environment which is within the range of the camera. And sometimes you have to make sure that there is nothing that may simply embarrass you in front of the camera once you realize what is being shown to other participants. You have to make sure that the premises are noise-free or there are any other disturbances. And such technical things as set your camera right in order to be visible, so that your face is visible, or not some other parts of your body or some other parts of your room, for instance. To suggest that a person should choose a well-lit place, not to be moving or not making any erratic movements while giving testimony, because you have to make sure that this remote hearing is as smooth as possible. So that completes my speech, and I will be ready to answer your questions, and thank you for your attention.
Thank you very much. Thank you very much for this really interesting presentation. And when you mentioned that a person could not sleep overnight, having received someone I could not sleep. I can understand him, but maybe I wouldn't be sleeping either. Would you be having good sleep if you receive someone? No, not really. I was representing my member of my family.
Aš atsiprašau, čia pašalinio triukšmo kiek buvo atsiradę. Sakėt, tvirtai toj situacijai.
Sorry for these technical difficulties, but the lawyer was saying that she was not feeling very sure about what was happening, what was going to be happening in the court hearing. So thank you very much to Victoria, and then maybe in the meantime we can look at the voting score. Did people approve of remote court hearing? So only 9% said that the experience was negative in remote court hearings. 42% mentioned it's more positive, and 47% said it's neutral. And so this result allows me to conclude that one way or another, court hearings are organized quite smoothly. It would be interesting to find out where that negative rating came from. But in one way or another, perhaps we can think that remote court hearings can be used in the future, even after the pandemic is over, because some cases, even criminal cases, can be examined by remote means, and that has a lot of advantages, saves a lot of time for the court and the witnesses and so on. So I am now, after a very short break, will be introducing our next speaker.
We
are coming back to our remote tools and equipment. So the speakers are all invited to switch off their equipment, and our next speaker is Mr. Thorn. Are you ready, Mr. Thorn? Mr. Thorn?
We are coming back to our remote tools and equipment. So the speakers are all invited to switch off their equipment, and our next speaker is Mr. Thorn. Are you ready?
Yes, I'm just unmuting the translation, so I don't hear the Lithuanian translations.
Yeah, okay.
Thank you very much. And good afternoon to everybody. It's a pleasure for me to take part in this conference, which has its focus on a very essential and important subject. As Irina emphasized before lunch, there's a growing recognition of the status of a victim's rights. So in this respect, it's very important subject of the conference. I'm not going to talk that much about victims. My issue is more on witnesses in general, and not only witness supporters, but in general witness support. So I'll come back to that. I'm sorry, I don't have anything to share. I mean, I will share my opinions and thoughts. So you have the disadvantage just to watch me and of course to listen. I do have some comments to previous discussions, but I'll leave that after my presentations, and I'm happy to receive questions and comments to my presentations, of course. I will speak mainly from the perspective of a Norwegian judge, which means with reference to Norwegian legislation, Norwegian practice, but I will have also, of course, a view to some international aspects of the subjects. I guess many people, being witnesses or not, would feel rather vulnerable if standing in front of a judge in a courtroom. Most parties to proceedings, being criminal or civil, they do have an attorney, and their needs will thus not be of major focus for the court. Although some parties do have a bad or incompetent lawyer, and for those people, vulnerable or not, the judge has an obligation to assist them, especially to clarify arguments, legal arguments. And this happens sometimes that judges, have to intervene on behalf of party to clarify the attorney's arguments. And also some vulnerable groups do have access to free legal aid, and they also have an attorney. So I think this is something to have in mind when we're talking about vulnerable groups in court. They might have an attorney. It doesn't mean that there is no problems, but at least in Norway, there's a variety of options for vulnerable groups to have access to free legal aid. I know that this is not the case in all countries, but it's also growing, right? Especially for victims, of course, they do have access to such attorneys in many countries. But of course, the resources and the conditions, whether you have this kind of possibility, is sometimes limited. So I'm going to talk about witnesses. And normally, nobody takes care of witnesses in court, except if you are a victim. As I said, sometimes victims have access to a lawyer. And this was a rather new concept a few years ago, that victims actually had access to an attorney. Now it's a normal procedure that victims do have access to such an attorney sitting by their side in serious criminal cases. One of the most essential elements in the considerations and deliberations of a judge when deciding on the guilt in a criminal case or in the evaluation of evidence in a civil lawsuit is the witness testimony. I think it's the most important evidence in court proceedings. Of course, the DNA analysis or other technical evidence by documents might seem more robust. However, a human person can often tell you much more than a simple technical analysis. A tear in the eye or a rise in the voice can sometimes tell you much more than a document can explain. Anyway, witnesses are just human beings, and you know probably the saying that one never hears more lies than in a courtroom. But just because witnesses are human beings, they need to be treated like such. When I work as an attorney, I observe many judges not acting decently to witnesses. And what you need to do as a judge is to create an atmosphere of the 3 C's: calm, comfort, and confidence for witnesses. We all know the phrase, a safe and secure witness is a good witness. And this is a fundamental precondition for a witness testimony. And if you can rely on a witness, then you'll be, as a judge, on the track to a correct decision. So this is what we are looking for as judges, something we can rely on. Reliable evidence. And reliable evidence is a precondition for effective proceedings. And this will eventually, in most cases, lead to a correct decision and constitute the rule of law in court proceedings. In other words, a fair trial. So how to create this setting where the witness feels safe and can give testimony that will be of relevance and importance? This is the challenge of witness support. And witness support may take many forms, either by legislation, by attitude from the judge, or by support services, by witness supporters, or court volunteers, as they also say. Needless to say, a basic requirement is that the legislation must be supportive of the rights of witnesses. and the last years have been tremendously supportive to the rights of victims, especially after the introduction of the European Union Victims Directive, as Irina touched upon. And also, you have also tools from United Nations. And the right to be present during hearings, the right to an attorney, the right to comment, those were rights introduced. However, not yet, at least in Norway, it's not introduced yet, and this is the right to appeal. Also, there is some rights that will be different in different countries. For instance, the right to be informed about changes of address of a convicted person, or to be informed about release from prison. So actually, this group of vulnerable people, persons, victims, is taken very well care of in the legislation today, I think. But then we come to ordinary witnesses, the ones who normally have no attorney, the ones who might not have suffered, but just observed something. But here I made a mistake already, since many witnesses actually did suffer. They might have observed someone who murdered another person or did something harm or cruel to another. On top of this comes the burden of giving testimony in court, and where they perhaps never have been. So it's essential to give also ordinary witnesses rights and tools to enhance their performance in court. And also to witnesses, the legislation is basic to this end. The right, for instance, the right not to testify if you are related to a party, or the right to testify as anonymous on certain conditions. But actually, there is not so much legislation related to witnesses as there are to victims. And also internationally, there are far more conventions related to victims than witnesses. Of course, victims are also witnesses, but they're a special type of witnesses. Now, for witnesses, one has to distinguish between witness protection and witness support. Witness protection is provided by the police and is an element to protect witnesses from intimidation, identity, and harassment. And such a service is quite common in most countries, I think. Witness support, however, is a service normally provided by an NGO or private supporters, volunteers. But how can we, as judges, support witnesses without being part of the witness support service? And this is very important, I think. The way I, as a judge, address a witness can affect the validity and quality of the witness testimony as evidence. Victoria also mentioned this in her presentation. I think it's very essential. First of all, we have criminal procedure regulations on how to address witnesses. And judges also have a code of conduct, which will apply to all behavior of the judge in the courtroom and also outside. And every year, there are some decisions from the Supervisory Committee for Judges condemning some behavior of judges related to witnesses that did not comply with the judge's code of conduct. But my duty as a judge is not only to restrict myself in how I approach witnesses. I also have the duty to limit the other actors of the courtroom, such as prosecutor and attorney. And they cannot approach witnesses in the way they like. I many times had to limit both prosecutor or lawyer on how they questioned witnesses. But of course, sometimes there is a fine balance to let prosecutor or lawyer put some pressure to witnesses so they actually tell the truth. However, one has to protect witnesses from harassment harassment and excessive questioning. In Norwegian legislation, it's the judge that questions the accused. And this is supposed to be so because the judge is supposed to be a neutral person, of course. But for witnesses, it's left to the parties. So the attorneys will always ask questions first. But the judge will, of course, ask questions and may also intervene if the questioning is not going correctly. Now, I have a surprise for you. I will share something which I hope will be positive. If not, I will not do it. Let's see here. Okay. No, it's not there. Okay. I'll skip that. Many witnesses are afraid of meeting in court, especially if they have become a victim of crime. But also ordinary witnesses are afraid of giving testimony in court. And there are several ways to facilitate testimony that can reduce this fear of meeting the eyes of another party or an accused in the courtroom. Some of the presentations have focused on this also. I think it was Victoria. Sometimes I suggest that the other party just, or the accused just is being put behind the witness or behind the curtain. And then we'll not face each other. And there is also in the legislation an option for the accused to sit in another room with remote communication to the courtroom, for instance, by video link. And the accused is not to choose whether to sit in the courtroom or not. It's up to the judge to decide. And if the judge considers that the witness will not be able to testify freely or without fear, I can, as a judge, compel the accused to sit in another room. But of course, I try to avoid this as much as possible. And this setting is actually a typical issue where the witness supporters can comfort and explain the witness to reduce such fearness. And we also have special arrangements for minors in some cases, where there is an issue of sexual abuse of minors or domestic violence, as also some has focused on. I think it was Irina who explained about the Romanian practice, and also Irina touched upon this with the Barnehus Children's House, where they have these multidisciplinary facilities for children. Originally, it was a panel with a judge and a special qualified police officer to question minors. And in this meeting was also prosecutor and lawyer present. Now, it's been a slight change to this, and there is no involvement of the judge. So there will be just prosecutor and the lawyer, and the child will be questioned by a special qualified police officer in a special designed room for kids. And after the interview, the whole video is saved and it will be played in court. And there will be a printout of the interview. And this procedure is established to protect the vulnerable victims and witnesses. Another issue I'd like to touch upon is the presence, the appearance, the turning up of witnesses in court. Since witnesses are one of the most important proof of evidence for a judge, it's paramount that they actually come to court. So how to support witnesses to come to court, to encourage them to come to court? In Norway, it's a tradition and common that people come to court if they are summoned. Most people consider this as their moral duty as civil citizens. in criminal procedure, it's a legal duty. If they do not appear, they can be forced by police. But in civil cases, it's voluntarily, unless summoned by the court, which is not so common. But most persons called as witnesses come to court also in civil cases. I had the pleasure to spend some time in some other countries to contribute to the support of the rule of law. And I was 1 year in Ukraine and 1 year in Moldova. And what struck me when I observed court proceedings was the endless proceedings. One court hearing was postponed after the other. And what kind of impression do witnesses get when they are called to a hearing but have to return home without testifying? Or maybe have waited for several hours without testifying? With just giving the message of postponement. Also, the refund of expenses for travel was a big issue in some places. So if people do not get the experience and impression that their contribution is essential for the judge or for the result, they will not turn up and give their testimony. And the result is no confidence in court trials or judiciary or the rule of law. And in some of those countries, both in Moldova and Ukraine, the confidence in court judiciary were just a few years ago 25%, which is not very much. So when talking about support of witnesses, it's essential to know that confidence in court system also has connection to how proceedings are run. If proceedings are not run properly, witnesses will probably give a damn and do not return up because of mistrust to the system. So you cannot establish a witness support service unless you have established well-operating court proceedings. When I experienced those issues when I was in Ukraine, where I work from the European Union, my local colleague and I established a pilot project with a local court and a university with law students as witness supporters. And we launched a website for witnesses where they can find information about what to expect as a witness in court, the rights and duties, all kinds of legal and practical information. And for the last 12 months now, 2,900 unique visitors visited this website 19,000 times. So this website was very successful, but after a while it turned out that witness supporters still did not meet too many witnesses in court due to the fact I explained that witnesses didn't turn up or their case actually was cancelled or postponed. So how to attract witnesses to turn up in court is still a substantial question for me. And maybe some of you have some suggestions. In Norway, the experience is quite different. The witness support service is successful and witnesses get all kinds of practical and mental and human support. It's run by the Red Cross with volunteers in cooperation with the Norwegian court administration. It was introduced in 2006 and is now operating in almost all 70 courts in Norway. And for your information, Norway has approximately 5 million in population and with approximately 700 judges. So each year, approximately 70,000 witnesses are questioned in Norwegian courts. At the introduction of this service, some judges were skeptical, since they had the opinion that such a service would interfere in their work and interfere with their competence. But today, nobody and very, very few things like this. The Witness Support Service of Red Cross and Norwegian Courts Administration has produced some very interesting and instructive videos which are illustrating how supporters should operate. And it's actually on YouTube if you search for it there. And they get, the witness supporters get necessary education and are informed about the legal system and the legal procedures and how to address witnesses. And they are told, and this is very important, they are told not to be legal advisors and not to talk about the case itself. They are just human colleagues and mental supporters who actually can give witnesses also some practical information. It's essential that witnesses are explained in advance to the actors of the courtroom, the sequences of their performance, what are their role and how they address witnesses, and the progress of the proceedings. In this way, witnesses are feeling confident and their role and familiar with the procedures. And witness supporters were first introduced only in criminal proceedings, but is now also common in some civil proceedings, especially where tensions also can occur, for instance, in family cases related to custody of child, for instance. So many countries like Lithuania now have established a witness support service. And when we launched this pilot project in Ukraine, we got inspiration from the UK, from Sweden, from Lithuania, and from Norway. I'm not sure where they have the most success with these services, but there is an evaluation made by the Norwegian Chief Justice Bernt Bahr and Senior Advisor Jenny Mellum of the Norwegian Courts Administration, who wrote about the implementation of the Victims Directive in an article in International Journal of Court Administration in 2017. And they evaluated the scheme in many countries. And their conclusion was that the UK had a very good system of protecting victims and witnesses. But their opinion was that there should be a change of mindset and culture in many countries in order to strengthen the rights of victims as witnesses. So even if many countries have implemented the directive, some improvements of attitude is still required in their opinion. And this is also my opinion. It's my impression also. Without evaluating the witness support service and how it works, one cannot say if it contributes to more effective proceedings. So one has to evaluate, and this has been done in 2012 and 2018 in Norway with positive results. In 2012, 25% of all witnesses questioned utilized this service. I mean, not 24% of all witnesses, but of all witnesses questioned about this. And in 2018, it was raised to 31%. But one thing was a little bit disappointing. Only less than 50% had received information about the service in advance. So more effort should perhaps be done on the information side that this kind of service actually exists. So that's why a website maybe can be very informative and a useful tool to introduce this service. And for those who want to know more about how witness support is organized in other countries and how it was established in a concrete country, I can recommend a UNDP report from Croatia. It was issued some years ago in 2012, but it gives a very interesting introduction to those services in many countries, and especially some valid arguments on why you should introduce such service. Let me finalize this presentation with an issue that has a great impact on the quality and validity of witness testimony, and which has some relevance to their support. And this is how the police are interrogating witnesses and suspects. How the police conduct interviews have a profound impact on the outcome and fairness of the subsequent criminal proceedings. Fair trial starts at the crime scene and in the interviewing room. It's of most relevance to suspects, but may also apply to victims and witnesses. The classic model is the confession-oriented model, where the investigator has a hypothesis of guilt he or she wants to verify. But the new model is a model taking into considerations human rights standards and is more a soft approach to the interrogated person. This model has its basis on scientific research and has now been a standard model for the Norwegian police. But in many countries, the classic model, which we still observe on TV series, is still the chosen one. And the Norwegian investigator and the superintendent Asbjørn Rakleb has been a major force and initiator for this new model, and the United Nations has taken his concept to introduce it as a UN standard model for police interviewing. And the point for me here, in our setting, is that if witnesses have been exposed for such methods, it's very hard for the court to circumvent previous statements in police documents. They might have suffered much pain and may not tell the truth because of fear. And a human reproach by the judge and the other actors of the courtroom, including a witness support service, could very well rectify such bad experience from the previous investigative interrogations, and thus support the witness in telling the truth. Finally, there is no doubt that witnesses and their support and protection is of utmost importance in order to make a solid basis for the correct decision of a judge based on the truth. Safe and confident witnesses are alpha and omega. My impression is that witnesses are taken more care of in court proceedings than before. And also in many countries, this is the case. And thanks to the successful introduction of witness support service and the awareness of the needs of a witness. Still, there are challenges in our attitude to witnesses, especially to those that may be characterized as minorities. I feel, although, that especially the new generation of judges have a different approach, and in their conduct of court proceedings, they take the necessary steps to secure the fairness of the trial. Thank you very much.
Appreciate Mr. Tron. Many things to think about. Thank you for your contribution from Norway. And let me now jump to the panel session. Leiskite pereiti dabar prie mūsų diskusijos, ne monologų sesijos, o diskusijos.
Let us again move on to the last part of our conference, namely the discussion, the wrap-up discussion. And Irina Urumova, Kristina Mišinienė, Vladimiras Seniovas, Victoria Šelmienė, and Tron Gundersen are going to be the panelists. Yes, so thank you very much for agreeing to be part of this discussion. And I would like to remind the audience that if you could please switch off the microphones, those of you who are not speaking. I would also like to remind our audience that you can raise your questions by using the functionality which you see at the top of the screen. Allow me to start the discussion from a provocative question. Given that we are talking about that people are intimidated by the very fact of coming to a court, Victoria mentioned that sometimes even the court summons may give you nightmares or no sleep at all. Maybe court summons could be rephrased into invitation to help to administration of justice, like the court is now summoning you up to give you testimony. Are there any countries around the world, well, for instance, Armenia or Norway, what is their approach to calling up witnesses in order not to be intimidated by this process? So what is the situation in Armenia? So are people afraid of coming to court, and is it just as intimidating experience in Armenia as everywhere else? Hopefully, Irina is going to join us soon. And when it comes to other discussion panelists, you could also think what would be the best form of making a connection with the person whom we are inviting to be part of the proceedings. Maybe we could find a softer approach. Irina, can you speak now? Have you heard our question, or shall we repeat? So, Irina, have you heard the question? Can you answer it, or shall we repeat the question? We cannot hear Irina. Well, there is some time lag in cast, so maybe it takes time for the interpretation to reach Irina.
Yes. Well, I could not hear the question very well. Can you repeat it, please? Can you
in Armenia, in your society, do people fear the judge, fear the court? What's your thoughts about this?
Can you say it again, please?
Okay, aš gal pasakysiu lietuviškai, nes nežinau kokia kalba.
Because I'm trying to listen to both language versions.
I will try then to say in Lithuanian.
Let me just disconnect the English one.
Okay.
Yes, just in one language.
May I speak in English? It's okay.
Yes, of course. Oh. Yeah.
In your country, in Armenia, do people fear the judges, the court? What sentiments when they get invitation to come to the court they have?
Well, I would say that Armenia is probably not a good practice case study yet. Although there are changes taking place, there is much more trust in the justice system nowadays than there used to be in the past. But nevertheless, people, I would say there is respect for the justice system. The justice system has made great strides in combating corruption. But when it comes to protecting individual vulnerable groups, there is unfortunately insufficient recognition of that, both at the level of the justice system and at the level of society. This is something that needs to be addressed both top down and bottom up. So there is a need for action at the level of the justice system, its governance, all the justice chain partners, but also on the level of civil society. And unfortunately, I don't see much happening in terms of, for example, groups of people with disabilities or similar groups raising their issues. There has been significant some women's groups managed to put domestic violence on the agenda, but the legislation in itself still leaves much to be desired. So, unfortunately, there is a lack of widespread understanding of why domestic violence and sexual and gender-based violence are such important issues. So there needs a lot to be done in terms of changing attitudes, changing behavior also. So it's not only the problem of the justice system, it's also a problem of society, I would say.
Dėkui. Mūsų auditorijai tą patį klausimą noriu iškelti.
I would like to raise the same question to our audience. In what ways could we somehow dispel this myth of a dark and gloomy place as a courthouse? So could we somehow change a court summons into something sounding nicer, that you're invited to help justice, help administering justice instead of court summons? Maybe we could find a nicer way of inviting people to come to court. Would it be meaningful, or is it some sort of a playfulness that could be introduced in order to get this better connection with witnesses invited to testify? So please switch on the microphone first. Well, when it comes to renaming a court summons to any other way, would not have any major impact. I believe it is not the document itself which is intimidating, but rather what happens to you when you come to court and what you're going to be asked. So I think what needs to be changed is the behavior or the practice. The court practice has to be changed so that our court officials could start from themselves. Well, maybe you are right in saying that a court summons sounds somewhat intimidating. Well, I will say, I'm calling you up to raise a question and I'm inviting you to ask a question. So don't you see any difference? Well, I think that I think it is called court summons, and then as the text goes, it says you are invited to come to court to give evidence. But indeed, you are right in saying that the name itself should be less intimidating. But as you mentioned, the problem is not here. By your explaining in a pleasant manner, by asking how he or she is doing in this phase of his or her life, or by apologizing for disrupting the usual daily routine and inviting to give testimony at court, maybe we should introduce more human touch. How often does it happen that judges apologize to people? Well, I have heard it on a number of occasions myself. Has Kristina heard at least once in her life an apology from court officials? So where shall we start from? So in whose hands the ball is? Is it something really easily done, or is it somehow far-fetched? Maybe it's only a play of words, or maybe it's a difference in the behavioral patterns that would introduce the difference. I remember that the University of Michigan and Professor Chopkin was running trials on the levels of empathy in different countries. Unfortunately, Lithuanians were at the bottom of the list. And empathy somehow is not fashionable. It's not trendy in Lithuania. Well, we do not dare to be empathic, especially if you are in a certain position of power, to say, I'm sorry, maybe I made a mistake, or to speak not at the top level of your voice would be considered as a sign of weakness. Because if you're a person with the reins of power, how all of a sudden you have to be talking more human or being less powerful. So where shall we start from? What shall we do to make a difference in the system of courts, which is far less empathic when it comes to vulnerable groups? So, Kristina, what you would have to say on this? Well, by way of hearing to you, sometimes I thought that you were really talking about a very remote future, or that there is indeed a little to do with us. But when it comes to the court summons, I would suggest that this naming of a document would not make any difference. I can take examples from my practice. Let's say 10 clients of our center, out of 10, 8 would not turn up if they could only avoid coming to court to testify. Even at the stage of a pre-trial investigation, they might have wished for justice, or they might have expected it to be put on a plate, but they never realized how long all the processes or the proceedings are going to last. So 8 out of 10 would rather not show up at court to save themselves the trouble. So I think that if we started to talk about the judicial community, we are always willing to have more positive changes. But when it comes to impartiality of judges, I remember judges telling that we would like to be empathic, we would like to show our feelings, but we're supposed to be impartial. But then coldness or standoffishness or sometimes even an arrogance, are these the synonyms for impartiality? Does impartiality go hand in hand with coldness or cold shoulder? So is it really empathy? It has anything to do with partiality? Are we really willing to sell you our side of the story? So I really avoid whether empathy and impartiality are they indeed, is there an equation mark or not an equation mark between these two? Impartiality, it doesn't mean that you're senseless or sometimes being afraid to say hello to the litigants so that they don't feel that you are on their side by simply giving a pleasant and welcoming smile. Vladimiras, what do you have to say on this? I think that Kristina has spoken very much to the point here. I always try to explain the same both to officials at the migration department. Of course, I speak quite different with a different language when it comes to communicating with judges. So whenever I have to deal with asylum seekers and refugees, the task at hand could seem to be quite a controversial one. Impartiality and objectivity are legal requirements, especially when we are talking about a legal procedure that they are part of. Another important aspect is you should never raise empty expectations or unreasonable expectations. So by my behavior, I shall not give a false impression that this person all of a sudden is going to be granted an asylum seeker's status or refugee status. But at the same time, it doesn't mean that I don't have to be empathic. Throughout my career, I have heard a number of times that well, you don't seem to have helped me, but somehow I find it easier or less stressful, just because you've been talking to that person with respect, which makes a difference. One of the behavioral aspects which I sometimes note in my practice, it is called a judgmental position. So in terms of this area, there is yet another important aspect, and I believe one of the speakers rightly said today that just after suffering torture or has been subject to violence, or just because of suffering from a post-traumatic disorder or other complications, and he or she is speechless, simply cannot be outspoken enough or persuasive enough. We understand such an approach of a person as hiding something or lying something, even though at the core of this matter is that the environment and the conditions have to be put in place to enable this person to open up, to tell the story. So these are the challenges that we have to deal with, and this is the direction that we shall be moving to, so that we can find objectivity, impartiality, and empathy. I believe that it all boils down to practical habits, and you have to develop them simply. So these are not two conflicting areas.
To be neutral and empathic at the same time. Do you have answer?
Mr. Tron, is it possible for a judge to be neutral and empathic at the same time?
Could you involve yourself? Okay.
So I have a few comments to.
Is it possible for a judge to be neutral and empathic at the same time?
I think the empathic aspect will be to be polite. And I think a judge should not be emotional. A judge should be kind of neutral as to emotions, but of course, a judge should be applied to the code of conduct.
Sorry, it's okay. You could speak. We hear some noise, but you could speak.
Problems. I think the empathic aspect.
Could you turn off your that? Okay. Speak.
Yes.
It's okay.
Did you catch my first part?
Yes.
Yes. So I think if the judge is polite and keep to the code of conduct, I think most witnesses and victims will feel the empathic aspect in this respect, because a judge should not be emotional, and to be empathetic, it brings it in a little aspect, I think, of emotions. Of course, all judges have their heart, and many times I feel sorry for victims, and so sometimes I feel I'm sorry to hear this, and just to put these kind of small words in your questioning, and this is how I think the correct way to address and to handle these kind of aspects of the proceedings. So this is it's a difficult thing, because all judges they are just humans, and we have different personalities and different characters. So some would be more empathetic than others, of course. So this is just you cannot squeeze all judges into one kind of behavior. Some kind of leeway has to be as to personal characteristics, but the code of conduct is paramount.
Thank you. Victoria, galima jūs įtraukti šitą
Victoria, can we involve you into this interesting polemic on what would the role of the judge and how much, what kind of a degree of empathy, politeness, professionality, impartiality should be mirrored in the work of a judge? I think that the most difficult part for a judge is to remain impartial and empathic at the same time. So be not too emotional, not to demonstrate priority to one or other party. And this is one of the most complicated parts of our work as judges. It is maybe our language or the words or the tone of the voice, the body language that we use, or the way we word our questions could be the ways how to show empathy. Personally, I often ask myself, well, all of the judges have to be guided by the same principle that everybody is equal before the law, and we have to treat all the persons equally. And how to find this balance is not an easy task. Politeness could be, or some sort of neutrality would be the key, how to solve this dilemma. And how to be pleasing to everybody and at the same time maintain your professionality. We cannot demonstrate emotions, however difficult it may be sometimes, but we have to remain neutral. Just as Kristina was talking today about this provocative behavior of suspects, and we have quite a number of such provocating suspects, and it is up to the judge to intervene in an early stage of cutting down such behavior would be one way of showing your empathy as a judge. And we, the judges of Lithuania, within our community, we are always discussing to what extent can we show empathy to people without being judged wrongfully, in order not to be misjudged, because we may always hear some claims from the opposing litigants saying that the judge showed too much preference to one of the parties. You as a judge have to try to remain as neutral and as impartial as possible without showing any preference to either side part of the proceedings. So all the judges, are they taught empathy? Are they told that it is necessary to be empathic? We do talk about empathy, and we have a special training on the subject. For instance, there are trainings organized for judges how to deal with litigants, with minor children, and how to react, how to behave. And I believe that these trainings are more than welcome, and there are not too many of them. Such skills or such knowledge has to be updated on a regular basis. In Lithuania, we have regular trainings organized by the Lithuanian National Courts Administration on the relevant subjects, and it is up to the judge to apply the knowledge in practice. Kristina today was mentioning about specialization of judges, and one of the solutions might be to allow judges to specialize in certain categories of cases which are capable or willing to deal with certain categories of cases. Because, as has already been rightly mentioned, all of us are different, and the law as a subject is quite a straightforward profession. And when it comes to cases involving minors, it is not up to everybody to who can be capable of dealing with these cases, capable or willing to deal with such cases. In Lithuania, there are such possibilities of specializing for judges, and of course, the smaller towns have fewer such possibilities of specialization. We have always remembered that judges are humans as well. And by way of giving his or her oath, they are assuming a certain duty, a statutory duty, and they are willing to perform to the best of their ability to administer justice in the right way. But sometimes there are some conditions which make this task more difficult. I saw that Kristina wanted to say something. Well, I feel somehow discomfortable by way of bombarding all the suggestions and recommendations to judges, but I personally find it as a unique possibility to ask the questions I would never be able to ask. So I would still like to ask the question to Victoria. Coldness or arrogance is also an emotion, is one emotion, and somehow it is much more tolerated rather than a more active show of empathy. I really care about this because I've been noting this for quite some time. We don't see neutrality. We see either empathy or coldness, which may even grow into arrogance. So there are two extremes. So would you agree to saying that coldness or arrogance is also an emotion? Of course, 100%. Arrogance is also emotion, and this is a negative emotion. But I'm trying to visualize a judge. I'm trying to explain why the judge is cold. And coldness is perhaps one of the simplest and most accessible ways to demonstrate impartiality. I understand that coldness is some sort of an armor that you put on yourself, which is unbreakable, and you are to some external forces. Especially when it comes to human trafficking cases, most of the time we are talking about criminal gangs, about organized crime groups. I'm not sure how many judges are analyzing such cases. Is it a panel of judges or a single judge hearing? So you can visualize a judge sitting in this chair of a person with whom the powers has been vested. The final say rests with the judge. And this person, this judge, is still a person, and he or she is expected to do the duty of hearing all the parties and decide. I'm not dealing with human trafficking cases in the local court, but we do have such situations in criminal cases when you hear both parties to the dispute. And this realization that it is your word which is final, which makes the task a daunting task. And therefore, this coldness is somehow the way of hiding judge's personal emotion, and this inability to demonstrate that this is so difficult for me to make a task, or that you are not yet sure what would be your final ruling. Perhaps sometimes people are expecting too much from a judge. My colleagues, judges, whom I meet, usually I don't see their reaction or responses because now we are in a remote conference, but we do get some cases when you feel alone in the field with all the power. You. And in such situations, which are difficult ones, very serious crimes, and very strong positions of the opposing parties, and some extraordinary circumstances or experiences of the people involved in the case. And you are the one that you are given this duty of making the final judgment. So I think this I remember hearing once a concept which sank deep into my mind, which explains a certain behavior, and this is a self-preserving arrogance. And this arrogance, which is emanated from a judge, is understood as arrogance or demonstration of the rule of power. But I would like the society to think that maybe behind this arrogance armor, there is this self-preservation instinct which is helping the judge to do his or her job, regardless of the professionality, of the competence of a judge, and an immense willingness to help people. A judge is always under tremendous pressure, and the work itself is full of tension, and the pandemic itself brings us in very angry people, anxious people, when you are blamed for whatever you shouldn't be blamed for. So I think this is the goal of today, where to find those common ground or attempts to explain from officials involved in the proceedings how the parties to the proceedings perceive the judges and how the judges express themselves, their impartiality or their professionalism. And I want very much that the parties to the case would not take it as a demonstration of power, but rather as a self-preservation thing. Indeed, we have touched upon very interesting things. We talked about the well-being or feelings of vulnerable people, but now we have moved on to the different side of the table on how the judges feel when they have to make a ruling and what are the challenges to neutrality, impartiality, and to empathy when a judge is also under immense pressure, especially given that the society is having very high expectations from the system of justice. And you know, one person might believe that a judge is impartial, others might think the same judge is arrogant. So different people, different opinions. So I understood from listening to you that what makes a judge impartial to somebody makes partial to somebody else. I would still like to ask a question about the coldness of judges, and it is a very good topic. And I'm very happy to see that we're digging so deep. And I would like to ask this question to Tron, what he has to say about the subject. Do Norwegians believe that their judges are very cold people or arrogant people? So what is the general approach of the public?
What he has to say about the subject.
It's okay. You could answer now, Ms. Tron. Could you answer? It's okay. You catch the question.
Yes. Okay. You know, Norwegians in general are very cold people. They are not Latin people. They are not like Italians. They are cold and distant, like Finns and yes. No, I don't know, but in general, I think there is a very high confidence in the judiciary in all the Nordic countries. I don't know the exact percentage, but I think it's about 85% confidence in the judiciary in Norway, and compared to some other countries I mentioned, you know, this is quite substantial. But as I said previously, judges are very different. I mean, they are just human beings, and some are very soft, some are much more direct and harsh in their approach. Because sometimes, and maybe I'm on the more, I'm maybe not too soft, because I think sometimes you need to get the right answers, and the witnesses, they tend not to be precise because they are afraid, and they speak maybe something, they speak too much about things that is not relevant. So in this way, the judge has to be determined and direct sometimes. And some witnesses maybe think that this is a harsh approach, but it's just to clarify and to actually to get the truth. So you'll have the correct decisions. So, but in general, I don't think that people in general think that judges are cold, but they are a little bit distant, of course. And I just want to touch upon one thing that I think maybe it was the Chief Justice of Lithuanian Supreme Court that mentioned this. About how we dress, the gown. I mean, we don't have wigs, but of course we have gowns. In Sweden, for instance, there is no gown. They just have a suit. So also this might be different from jurisdiction to jurisdiction. But in general, I don't think it has a great impact on witnesses. It's the way you address them, not the way you dress.
Thank you. Ačiū. Ačiū mūsų svečiui iš Norvegijos.
Our guest panelists from Norway, and now there is still some time for questions from the audience. Anybody willing to answer them are more welcome to do so.
Kiek dažnai teisme pasitelkiamas psichologas bendraujant su pažeidžiamais
Psychologist is engaged in court proceedings when we communicate with vulnerable adults. If there is remote court proceeding. As far as I know, it is an increasingly often practice. We don't have a statistical data. Most probably nobody does. I've never seen any data like that. Maybe we should make this kind of estimation. But again, naturally, that depends on the judge. There is no one opinion on that. There are certain things that are to be taken care of. It's like to feel comfortable and to ensure that there is no secondary victimization. Now, speaking about involvement of psychologists in online court proceedings, that would be very complicated. Maybe involvement of a psychologist would interfere with the objectivity and unbiasedness of witnesses. I believe that with this extended pandemic and a lot of court hearings now organized online, most probably we will be using that increasing more often, but still many prefer arrangement. Then the next question is how the process participants have to give oaths during the court proceeding.
You want to react?
Okay. Mr. Tron, would you like to answer? I mean, how
Could you unmute your microphone if you want to react now? Mr. Tron? You wanted to react? No?
Hello?
Okay,
you
so
wanted to react, to interrupt in our discussion or not?
the question was.
You see, I have two screens, one with English translation and one with the conference in Lithuanian language. So I have to.
Okay. Let me.
And there is a delay in 30 seconds between the two.
Okay, let me repeat the question. The question is.
I didn't catch the question. Could you repeat if there was a question?
Yes.
But it was the question for the Victoria, for the Lithuanian judge. It's okay. Maybe Victoria could answer one more question. Ar galėtų Victoria dar vieną klausimą atsakyti dėl priesaikos? Aš atsiprašau, ar galite atsakyti dėl klausimą?
The question now concerns about the oath. I don't quite understand the essence of the question. In my understanding, the problem was how to sign the oath read. Well, there are several ways. According to the criminal proceedings, we have to keep the sign oath statement in the file. So there are several ways just to send it by mail, but then the witness would just to give an oath and later on send the written statement. I have heard that if the court hearing is organized on Zoom, the proceeding is recorded, and especially in the place where it is evident that the translator or that participants take an oath. But that has to be evident and heard on the audio or video recording. So, Kristina, the closing statement. What is the idea for Lithuanian courts? Maybe something simple, straightforward, just to ensure that the relation between the court and the court proceedings participants is friendlier and simpler. If I give you a magic wand and say that you can change this today, what would you do? So that is a very tempting proposal. If there is only one possibility to change something, to use my magic wand, would be to ensure that witnesses and victims don't meet the perpetrators in the courts. So I don't mean to say that we need to build new buildings or new additions to the court buildings, but just to take organizational measures. Vladimiras, I would like to speak about the entire system and maybe about the public authorities. But we've been speaking about empathy, but what I mean is humanity. I understand empathy is the ability to understand other people's feelings, their situation, to stand in their shoes. This is very often what I say to people with which I work. I very often to say to them that I understand you, I can hear you, but there are legal procedures. So that would be my wish.
Mr. Tron, if you could change one thing in the court, what it will be? Kas tai būtų?
Mr. Tron, there was a question for you. Manau, kad negirdėjau. Mr. Tron.
Sorry about the logistics here. First of all, I would say that I got a lot of inputs today about how to organize and how to conduct hearings. I appreciate that very much. And I had a few comments on special topics I would like to comment on, but I think time is running out, and also the complexity of the communication here doesn't allow me to be too professional on that right now, I think. So I just want to close this with appreciation of all the presentations and all the good advice and questions, which I will pass on to my colleagues. So thank you very much for an interesting conference and a very successful one. Thank you very much.
Thank you so much. Dėkui mūsų svečiams, dėkui taip pat visiems, kurie prie šio renginio prisidėjo savo pranešimais.
And also all the contributors to the event, Victoria, Kristina, Thank you to all the participants. If I have that wand today, one thing that I would like to change, I would like to call for confidence in courts. So I believe that this is in great shortage in respect of our institutions or public authorities or educational institutions. Without confidence, trust, it's impossible to move forward. And the trust and confidence is always a bilateral movement. So I would like to see that confidence between the victims and courts could be further developed. I believe that this half a day was useful. Our conference was not intended to address and solve and resolve all the problems, but our purpose was to touch upon the important issues, to speak about it, because when people start speaking about it, automatically, sometime later, the decisions come by themselves. We had a very open and honest discussion. We put ourselves in the shoes of judges and the victims and the witnesses, and that was very useful, because when people start understanding how people feel in their position, we can expect much more empathy and much more efficient decisions can be taken. Thank you to organizers and all the contributors. I believe it was successful. Be healthy, stay healthy. Today, being healthy is the largest Christmas gift, and I believe that the holidays will be still warm in your heart. Thank you. Bye-bye.